some associates gather on the stand. This trial's a circus, but I've got a plan. Not a grifter, still worse than Dan. Hopscotch squares, don't trip, don't fall. BK in a felony, I've heard it all. Shake it, magic 8-ball. Tell me the truth, will justice call? Me be the diva, she's running the show. To Capone and Meg, yeah, everybody knows. Fat, we're fat, well, nobody knows. What the corn echoes as the chaos grows. My credibility left in a vehicle. Hopscotch squares, don't trip, don't fall. BK in a felony, I've heard it all. Shake it, magic 8-ball. Tell me the truth, will justice call? What the corn echoes as the chaos grows. My credibility left in a vehicle.
Hello, happy Tuesday, everyone.
Down the rabbit hole.
Down the rabbit hole we go. Where it stops, nobody knows.
Nobody
figure it out one of
knows.
these days. We'll get to the end of the internet one of these days. Maybe. If we're lucky. What's up, Heidel Secondish? Secondish, whatever. Oh, Bad Dazzer. You've been in the beavers in Discord today. I saw your comment. I'm like, I'm not even gonna go look.
Unfortunately, I looked. So. Wasn't these dang beavers never getting away from?
I was like, holy crap. What's up, Chloe? Good to see you.
Chloe.
Snipe. Nice song. Nice song. I sent it to our little poopster.
Oh my god, I'm gonna call her that. And she calls me, I'm like, "What's up, poopster?"
What's up, Flashman? Flashman, no reason to lurk today. We're not getting into anything heavy. There's nothing like the trial. So no worries there. You can be here and feel safe if you want to. What's up, whoever? Oh my gosh. What's up, Mrs. McPickle Pounder?
Carmy poo.
Carmy. I thought, when I heard you say that, I hadn't got all the way down to the bottom yet. I thought that was going to be Brie, because some people used to call Carmen, when she was little, would call her Carmy. But I don't think they really do anymore. Carmy poo.
Carmy poo.
I saw Flashman. I just have not had a chance to. I saw that you sent stuff. I just haven't had a chance to look at what you have sent. So I was running around with my dad today. Then I got home. I was on the phone. Then I ate dinner. Then I came down here. I was like, holy crap. I gotta get stuff ready. So I will look at it and thank you. Okay, so I will give I'll give a summary kind of this woman. She is the worst. She is one of the worst human beings I've ever seen in my life.
Facts. Oh, hey, Bri.
What's up, Bri? How are you? What's up, Bri? I don't know what happened to my voice there.
What's up, Bri?
What's up, Bri?
Hi, Bri Bear Poo. Pooh Bear.
I have no idea, Bri, but hello, Bri. How are you?
Your voice
you are right on time.
The other thing that went down this time.
Flip your hair. Hi, Bri.
No, do the deeper voice. Hi, Bri.
Hi, Bri. What's up?
That was awesome.
Was it? Was it really?
It actually was. It kind of made my night.
Gabby, are you in a grain silo? Why do you ask that?
Okay. I don't know what you're talking about. I'm in my room.
She got grounded. She's in her room.
Yeah, I was in my room.
She's sneaking. Like, shh. She doesn't know. Her parents don't know. But anyway, all right. So, Shanda, I don't care how to say her first name. I never can remember because I don't care to remember. So, it's one of the ways, it's one of those two ways.
Why would I bring the
Carmen
computer
always,
in the bathroom?
that would be funny.
It's gonna be uncomfortable.
If we just hear the toilet flush.
That'd be so uncomfortable. Like, let me just sit on the toilet with the computer on my lap so I can be online still, but you guys can hear me take a piss or something. That is so awkward. Like,
Whatever. Whatever you're doing. Whatever. Oh, gosh. Let me pull up my notes. All right, Gabby, I'll let you watch chat for a minute. So this trial took place in December of 2023. Shanda and her son, Paul Ferguson, were accused of causing the death of Shanda's 15-year-old son, Timothy Ferguson, Paul's brother, obviously. It was a bad way. They starved him to death. The abuse this poor kid had to go through was awful. We're talking wall sits for long periods of time, or running stairs outside with his brother Paul chasing him. And he's a tall dude, and I'm sure Timothy was scared of him. They also made him eat bread or crackers with hot sauce on them, and I am talking extreme hot sauce, not just the stuff you get, not Frank's hot sauce, you get not Tabasco, horrible stuff. They read the label on it during the trial. It was bad. It was really, really bad. They would make him eat bread with that, and he would have to, if he kept it down, then he could have more food. They would also put it on his genitals. So I'm sure that was torturous. They would make him take ice baths. They bought leg shackles from, I guess, off Amazon, apparently. Go Amazon. And shackled him to his bed. They also...
wall sits.
Yes. In the garage with no clothes on. This was in Michigan. All the food was under lock and key in the house, except for the dog food. Shanda trained Great Danes, which pisses me off too. She didn't deserve those dogs. She wanted them as service animals, and I think it's because she's a short person. She's a little person. I think she's maybe your height, Gabby, if I remember correctly. She's very petite. Well, she may be just 5 foot then. So, shrimp. Taller than Ronnie, shorter than you.
For goodness sake. It's not called a shrimp by AJ.
So, no, I called her a shrimp because she's shorter than you. I don't know. She's very petite, small woman. I think she...
Hear that? 5'1" isn't a shrimp.
I think she honestly wanted a Great Dane service dog, because that's not a service dog that you normally see, to just show people, look how much control I have over this great big dog.
Yeah.
Good for you. They ate freely in the home. Their food was not under lock and key at all. And if Timothy was found to have went to and stolen food, then he was punished even worse. So he ended up, when he died, he had been put in an ice bath for hours.
Terrible.
And Shanda told Paul, because Paul was like, I think we really need to feed him. And by that time it was probably too late. She told Paul he was probably faking it, and to take a pizza roll and hold it up in front of him while he's in the ice bath, and he cannot, he's getting to be non-responsive at this point. And if he tried to take a bite, then he obviously was faking. But he wasn't. When she finally got home that evening, we did not see this video. Thankfully, the judge was very, very good about not showing us any pictures of him in his final days. She drags him down the hallway to a closet that they also would keep him in. It has a tarp on the floor. She puts him in there with no clothes on or anything. I believe she was calling him stupid and horrible names. She has cameras always watching him. So she puts the camera on him, and he tried to turn
all the cameras.
Yeah, all the cameras.
There's cameras all over that house.
Yep. She's just a nut job. He turned his head away from her, and she made him turn it back. I mean, this kid is dying at this point. And the next morning, he's passed away. They don't call 911 right away, because why would you do that? They get him dressed. They dress him in baggy clothes so that he doesn't look, he was 69 pounds at 15. So that he doesn't look so thin. Well, I'm sorry, you can't hide that. I don't care how many layers of clothes you put on him. They claim that they tried CPR. I don't know that they did. I don't believe the medical examiner said he had any like broken ribs or anything, which, being that thin and fragile, you would think that CPR would break his ribs, or at least one of them if they were doing that. Her story was that he went on a hunger strike and he refused to eat for whatever reason. I don't know.
But he also had he was on the spectrum as well. He had autism as well. So I don't know.
And
that was sad.
The reason he ended up there is because his dad couldn't handle him. Allegedly calls her and tells her that he can't handle him anymore, and he needs to go be with her. The problem with that is she wasn't allowed to have custody of any of her kids. That's how great of a mom she was. I mean, she's human garbage. So he comes there. Paul, at this time, he's an adult, so he can choose to do whatever he wants. Paul pleads guilty. He ends up testifying against Shanda in her trial. He got me. I thought that kid was brainwashed and was just like doing what he was supposed to do so that he didn't get in trouble by his mom. Turns out I don't believe that is true. I think he was completely in on it and complicit with all of it. So he was very shocked when he was sentenced. I think he got, 40 years or something crazy. He's just, I don't know. I don't have words for these people. I don't know why her ex-husband, did not get in some kind of trouble. Because he gave her the kid. He gave her Timothy and he wasn't supposed to. I don't know. They're just all not good. Well, not all. I don't know. I just can't with this woman. I'm trying to go back. If I've missed you and not said hello, because I haven't been able to see chat. So
do I sound better?
You sound fine to me.
Well, I guess I'm asking Bobby, because he said I sounded like I was in a bathroom. Do I sound less in a bathroom now?
I guess.
Although I guess my bedroom is kind of echoey.
But
so
you're in there all the time.
I know. I don't know why. It sounds fine to whoever. That's the only thing that counts. So thanks, Bobby, but no thanks. I got my answer.
Hello, Salome. I don't know if I'm saying your name correctly. Yes, Shanda is very narcissistic. She's awful. She's awful, and she has tried to become the victim in all of this. I'm going to play you guys because some of you haven't seen her original trial. It's horrible. Yeah, it's bad. So I'm going to play just 15 minutes. That's true, whoever. The hospital is going to cut all those clothes off anyway. But you just reminded me of something. So he died of severe malnutrition, severe dehydration, and hypothermia in July. That's what threw the medical examiner, because she was like, how did that happen? How did he have hypothermia in July? It's Michigan, but it's freaking July.
I remember this. I remember, yeah.
Yeah. I can't with her.
I remember what the medical examiner said. Why it was hypothermia, because his body weight was so low. He didn't have his body. Usually when you're super cold, your body will shiver to warm your muscles and everything up. He couldn't even do that because he didn't have that much muscle mass or any type of fat on his body because he was malnutrition, So that absolutely so sad. That poor kid.
Bryce said you still have a potty mouth.
I know. I said, Brian, that will never change.
Even if you aren't in the bathroom. So we're going to watch. So I told you guys yesterday, there was a part in the trial where Shanda gets sick, right? It's pathetic. It's about 15 minutes of her cross-examination just to give you a taste of what the prosecutor did. An excellent job on this trial. I will tell you, when I streamed this trial, I was not a fan of prosecutors because I had watched a couple of trials that really just absolutely... I quit watching them for a few months because they just absolutely... I couldn't believe that they brought the trials that they brought. And then those people... one was found not guilty, which I was so glad, but one was found guilty. And it just... I was like, I'm done. I can't watch them anymore. So I was not a fan of prosecutors when I very first streamed this trial. I have now since balanced. Believe that or not, Bobby. I'm balanced out, and I try to give credit where it's due. This prosecutor did an excellent job. This judge did an excellent job. The defense attorney, he did an excellent job. So I don't have anything bad to say about any of them. I was just seeing if you were paying attention, Bobby. You weren't.
He is. He's too worried about me being in the bathroom for some reason.
I guess. What's up, Deidre?
Oh, he was
How
shaving.
are you?
Sorta. So you're in the bathroom.
Yeah, Bobby.
Hey,
I do
Deidre.
not have a headache today. I wore my other contacts today, and I actually almost wore them on stream, but I didn't because I didn't want to rip my eyes out today, and they didn't give me a headache. So
I'm glad you didn't rip your eyes out today.
But they were kind of starting to get to me, so I was like, yeah, taking them out. Oh, yeah,
Okay.
Great judge. You guys are going to see a good judge. You're in the bathroom. Get it?
But
Tickets to... All right.
rah rah rah.
Rah, rah, rah. No, that comment is staying in my mouth. Oh,
I can't.
Bad Dazzer. You don't even have to comment. I'm good.
Just put up the roses now, because Jesus.
Yeah, this is fine. It's fine. All right, so we will watch this. This is 2023. Just to give you a taste of what happened, and then we will go to her hearing that she started. It was her second time because she's She's just pathetic. Then we will get to the hearing that she had in 2025. I didn't play it because, well, it didn't conclude that day. So we'll do that, and then we will do what happened last week on Thursday. Is everybody confused? If you are, that's fine.
I think I can follow
All right.
it, but I'll probably ask about it later.
That's fine. I'm all good. All right, let me know how the sound is. It's been a long time since I've played a video off of YouTube, and not just off a website.
Okay.
You're lucky. I'm busy with. I'm lucky that you're busy keeping up with your divine image.
Okay. Ugh.
Okay, Bobby.
Bobby.
Whatever
Bobby
you say.
Dave
Bobby.
Bologna.
Bobby de Bologna.
Right, you may be seated.
Sounds perfect to me.
Thank you.
All right.
Ms. Vander Ark, I think we're just finishing up. I was just talking about the ice bath with you. Again, your text was, let him know that if he tries to sleep at all, he'll get another ice bath sometime before you leave for work, and another when I get home. So let's break apart that sentence for just a moment if we can. And that was on March 27th. Right, so yeah, about 9 days or so before Timothy passes away. Let him know that if he tries to sleep at all, let's start there. This is at 3 o'clock in the morning. You're saying he is not allowed to go to sleep, right?
Yes, sir.
So 3 o'clock in the morning, your 15-year-old child is not allowed to be sleeping. And if he does, he gets an ice bath, right?
Yes, sir.
And he'll get another ice bath, i.e. there's already been an ice bath prior to this text being sent, correct?
No, sir. It would be one and then another, is what it says.
Okay, well, let me read it again and make sure maybe I misread it. Let him know that if he tries to sleep at all, he'll get another ice bath sometime before you leave for work, and another when I get home. There's two another's in there, isn't there?
Yes, sir.
The first another refers to the first ice bath. In other words, there's already been an ice bath, right?
I mean, I don't know. I'm not questioning what's in the text, but I don't know.
Okay. And then sometime before Paul leaves work, he'll get another ice bath, and then another one when you get home. So 2 ice baths, in addition to the one he's already had, right?
If that's what it says.
And that's for the crime of sleeping.
I don't know what the original, whatever happened before that.
But you know what it was to get him to not do another one, right?
Yes, sir.
Let him know that
What
if he
it
tries
says.
to sleep at all.
That's what it says, yes, sir.
Yeah. Might want to toss the ice that is made into some Ziploc bags in the freezer tomorrow for if we need a bunch more. I think that kind of speaks for itself. We'll move on. Let me show you an exchange from May 9th, 2022. This is pages 5348, 5348, sorry, 5347. Oh, give me just a second. I apologize. Okay, start at page 5340, and this is from May 9th. I don't think you need to read the top one. That's Paul's message. Go ahead and start reading there. From May 9th, 2022.
What is daddling anyway? Please make sure Timothy goes into his room with the alarm on when you leave. I should be home not too long after you go, as long as you before you go. And please let me know where you put the alarm when you leave.
All right, let me stop you right there. This is May 9th. And again, you're referring to an alarm, correct?
Yes, sir.
Okay.
This
Go
is, okay.
Go ahead.
Because I know what that's referring to.
Let's keep going.
Okay. KK, thanks. YW, you're welcome. I logged out of that for you, but you will not be allowed to have any devices tomorrow before work unless you manages to get everything done I assign to M standards, which will not be easy. I'm not sure what part of Timothy going nowhere but the bathroom without being watched closely, but he stole a bunch more of the Easter basket today and hid the wrappers behind the washer and dryer because he obviously wasn't washed as he should have been.
Okay, so at this point on May 9th, you're saying that Timothy needs to be watched if he goes everywhere except for the bathroom, right?
He needs to be watched, yes, sir.
For committing the crime of what?
We had a combined Easter basket that year, and so I had divvied it out between everybody, and he stole some that was
Gabriel with cheese and
I don't remember if it was Paul's or mine, but he'd already had his portion of it.
So taking candy from an Easter basket means that he gets watched and can't have any privacy anywhere except the bathroom, right?
Yes, sir.
Okay, keep going.
It was a star. What part of watching Timothy closely was unclear. Sheesh.
Let me stop you right there. What part of watching Timothy was unclear? Why was it that you believed at that point that Paul wasn't watching Timothy?
I was correcting, it's the little star. I was correcting what, where was it? Usually if I use the star like that, it was for, to correct something that Siri messed up or something I messed up. I don't know, I'm not sure. I've only got these messages, I'm not sure.
Okay, but the part that you read there said what again?
What part of watching Timothy closely was unclear, sheesh.
Okay, so you were upset at that point that Paul wasn't watching Timothy closely enough, correct?
Yes, sir.
And the only way you would know.
Yes, this is Mom. She's reading text messages between her and Paul, her son, her co-conspirator in all of this horribleness. Yes, and she was working at the courthouse when all this happened. Yep, forgot about that. Yep. She's really smart. I mean that. Like, she's really smart. But she's just evil. Does she think this kind of parenting was normal? I have no idea. She wasn't even supposed to have him. So I don't know what her version of normal. I just don't like her. Baker. That's Baker. That's not nice. Baker 19er. Thank you. She's very smart. The judge even actually tells her that during her sentencing. She passed, I think she was first in her law class. Like, she was becoming a lawyer. She was very smart. I won't take that from her. 'Cause I'll take everything else.
Paul wasn't watching Timothy closely enough as if you were also watching Timothy closely enough, correct?
I don't know at that point. I don't know if somehow I found out about the Easter basket. Hold on. Okay, yeah, we must have been at a baseball game. It was 6:20 p.m., 6:43 p.m. So yeah, I must have been watching him from...
So you're at a baseball game for G and you're watching
Checking
Timothy
on it,
and
yes.
Paul to make sure Paul's watching Timothy closely enough. Correct?
Yes, sir. Yes, sir.
Do you remember all this text exchange?
No, sir, I don't.
You don't remember this at all?
No.
Okay, go ahead, keep reading.
Okay, there's no way that was today, Mama. Don't blame me. He
That's
literally...
Paul, right? Okay,
Yes.
so I didn't mean to cut you off, but that's Paul, right?
Yes, sir.
Okay.
He literally never had the opportunity to steal anything. I made sure of that.
The response to that is?
When he was putting clothes on my bed, he did actually. And watch, it's ye tone with me. Should have been the, not ye.
Right. So you knew that Timothy had done something when he was putting clothes away?
Yes,
right?
sir.
And the only way you would know that is by monitoring the cameras, right?
Yes, sir. I never gave him permission to even set foot in your room. I swear he must have done it when I went to the bathroom.
Okay, keep going.
He's trying to get me in trouble here,
This
Mom.
is all Paul, right?
Yeah, this is Paul.
Okay.
And I told him to go to his room when I did. I brought him downstairs with me so his sneaky butt escaped. I watched him go into his room.
And what's your response there?
I said he said he never asked, but I've mentioned before you need to take him downstairs when you go to the bathroom so he can't escape.
All right,
Yes.
Let me just, I think we can stop there. You don't remember sending these text messages?
No, sir.
No memory from this time period?
No, sir.
Because of all the blackouts, all the tunnel vision, all the PTSD, right?
Yes, sir.
Okay. He said he never asked, but I've mentioned before you need to take him downstairs when you go to the bathroom so he can't escape. That was what you said, though, right?
Yes, sir.
You actually used the phrase escape in relation to your 15-year-old child,
Apparently, yes, sir.
as if he was some prisoner.
No, sir.
Well, who else needs to escape but a prisoner? I'll withdraw that. May 9th, right?
Yeah, that's what it said.
You don't remember that at all?
No, sir.
When was Mother's Day 2022?
I don't remember, honestly.
If I told you it was May 8th, would you have reason to doubt that?
No, sir, not at all. I believe you.
Mr. Johnson was asking you, and you were very eager to tell him about something that you remembered happening on sometime just after Mother's Day, right?
Correct.
So Timothy got on a scale and weighed 108 pounds. It's amazing your memory is that good that you can remember what your son weighed sometime after May 8th, but you can't remember talking about having him escape. Would you care to explain that to the jury?
Yes, sir, that happened with the PTSD, with everything else that was going on. I would, especially when I got stressed, it would, the tunnel vision, and I mean, I can't, for lack of a better term, blacking out. Pretty much any time my stress level went up, and it wasn't up that day that we did weighed the dog.
So you can't remember all of these text messages about the ice baths and the hot sauce and the zip ties and the handcuffs, but you remember over 18 months ago that your son weighed 108 pounds sometime after Mother's Day of 2022, correct?
104, yes, sir.
104. You got it down. You're right. 104 pounds.
Well, he made a comment that just, things like that will stick out to me sometimes. And when he couldn't pick the dog up, bear in mind, this is a service dog in training, so he's used to getting commands. And Timothy, I remember he put his hands on his hips and looked at Sharma and said, "Next time you get to pick me up." And the dog tilted his head like, "I don't understand that command." And that struck me. It sticks in my head. I don't know why, but that sticks in my head.
What day was it?
I don't know what day of the week it was, sir. It was during the week.
How long after Mother's Day was it, then?
I don't remember, sir. I know, the reason I know it was after Mother's Day is because Mom, my mother-in-law, for probably the last 4 or 5 years, as a Mother's Day gift, has given me cherry tomato plants and then miniature cucumber plants, and I keep them in like plant bags. I normally have a black thumb, I admit it, but I've managed to keep these alive pretty well. And I had just, when I came upstairs to weigh the dog, I had just gone downstairs and checked on my plants. So the plants were outside then, so I know it was after Mother's Day, I just don't know when.
Plants never missed a feeding, then, did they?
Objection, Your Honor. Argumentative.
What's argumentative about it? She's proud of herself and keeping plants alive.
Plants never missed a feeding.
Mr. Roberts, it's an irrelevant question, so sustain.
So your testimony is Timothy weighed 104 pounds sometime after May 9th, correct?
Yes, sir.
That doesn't look anything like 104 pounds, does it?
No, sir.
That's not even a month, that's barely a month after May 9th, isn't it?
Yes, sir. I lose weight very quickly. I'm assuming he got that from me.
And again, the response to this was give him bread, right?
If that's what the text message says, yes, sir.
Mr. Johnson asked you about some text messages back and forth between you and Paul during the ice bath, the last day, the day before Timothy died. And you were observing that ice bath from work, right?
I glanced in on it. I wasn't observing the whole time. I couldn't.
You weren't observing the entire time?
Not the entire time. I glanced in on it.
Whenever you'd send a text message, you were also looking at the camera, weren't you?
No, I wanted Paul to think I was.
And Mr. Johnson asked you if you remember the text about, honestly, tell me if you think this is all fake. Remember that?
Vaguely.
You vaguely remember that
Yes,
text?
sir.
So you can remember the text where it tries to provide you with a defense to this, but you can't remember any of the horrible things that you did to Timothy. Is that your testimony here today?
I don't have any control over what I can remember and what I don't, sir.
You recall Paul's testimony yesterday about what he did in response to that photograph that he sent you about saying we really need to feed him, Mama? I think we actually need to feed him, I believe is the actual text.
Yes, sir. I remember his testimony.
And what was his testimony?
That he gave him peanut butter and jelly sandwiches, and I guess he cooked him some eggs.
That was the first time you heard about that, wasn't it?
Yes, sir.
And that was not his instructions, was it?
No, sir, but that was fine. I had no problem with that.
Well, why didn't you just tell him to make him some eggs in the first place then?
Because I didn't think of it. I was in the middle of something.
I think we actually need to start feeding him, and the only thing you can come up with, instead of Paul thinking to give him scrambled eggs, is give him some bread. That's all you could think of.
I don't know. I was in the middle of something. I wouldn't have thought of eggs anyway, not in the middle of the day.
You said that you would, the punishments, and I guess this 3 o'clock in the morning one about not letting him sleep or he gets an ice bath, so he's got to be awake at 3 o'clock in the morning. You said that was because he would keep you guys up in the middle of the night or wake you up in the middle of the night?
Yes. Yes, sir.
And again, you did really well on the logic and reasoning portion of the LSAT exam. Can you explain the reasoning behind keeping somebody awake when they're keeping you awake?
To show them how it feels.
But they're already awake, aren't they?
It made sense to me, sir. Now that you ask it, but it doesn't seem to make sense, but it made sense to me at the time.
You didn't actually mean that as a punishment. That was just out of spite. You were just angry with Timothy for keeping you awake, weren't you?
No, it was meant as a punishment, sir.
But it's also a punishment for yourself because you have to stay awake as well, don't you?
I don't sleep much anyway, but yes, sir.
Or Paul has to stay awake, right?
Yes, sir. Paul's an insomniac as well.
You testified that you gave Timothy a warm bath the night before he passed away, that last night, July 5th. Do you recall that?
Yes, sir.
That was the first time you've told anybody connected to this case that you'd done that, isn't it?
Yes, sir.
You never told the police officers you did that, did you?
No, sir.
I imagine a warm bath sounds just like, it's just what it sounds like, right? You got him, you took him to the bath, you drew a warm bath for him, and you put him in the bathtub, right?
Yes, sir.
This is hours before he dies, right?
Yes, sir.
You look like that when you put him in the bathtub?
I'm sorry.
Gotta make the old moment.
Yes. Ms. Vander Ark, do we have a trash can?
I did, I placed a
You
trash.
did?
Yeah.
Would you like the beard removed? All right, please rise.
Spoiler alert. There was nothing in the trash can.
Oh, well. Maybe it was magical. Like, no one
Yeah.
could see it but her.
Yeah. Yeah. Nope. Nothing in there.
She's chunkless.
She's a lot of things, Liz. Yeah, she was so stressed that I don't know how that mean evil prosecutor did that to her. Big bad
She's the
meanie.
worst.
Oh, she's horrible. She's horrible.
George! George!
Oh my gosh. What are you doing, George?
George.
How are you? It is about time to bring Linda back out for the summer.
It's almost time. Red shirt, hair up.
It is about time. Man,
Aw,
George, good to
George.
see you. It's been forever.
I was just saying the other day, I was like, I miss when George would call me his clam.
Yep.
We were the
Go
clam,
check
we were
on-
the clam sisters.
We were. Come check on my clams. Oh, my ears. Sorry.
Yeah, I bet you can
George
hear me
used to-
now, though.
Yeah. George used to hang out with us all the time. And he left us
Aw.
for Judge Wolf.
You know.
He's like, Judge Wolf, peace out. He's over on your side of the pond, Bad Dazzer, if you're still in here. And Haley. I don't think I haven't seen Haley. Oh, my.
I knew it.
Yep.
I knew George and Bad Dazzer would get along.
Absolutely. Let me get the next video up. Okay, so that was 2023. She never returned back to court until her sentencing. Rue, your timing. Your timing is so perfect. I just can't.
Love you, George.
Aw, thanks, George. Gabby always pops into Judge Wolf to say hi. Well, I just, I'm too shy to say hi in there. I've been in there, but I just lurk. I know that sounds silly considering I'm sitting here speaking, but
Sometimes when I don't see George in the chat for a little while and I go in there, I'm like, anyone seen George? Is George here? And then George is like, Gabba Sutra! Like, I knew you were here.
I knew you were here. You hiding.
You just had to say your name in the chat.
Yes. Then you appear. Okay, I will. Absolutely, George. If you promise to say hi back. Otherwise, I'll be like, okay, going back to my corner. Also, please come and say hi here more too.
Yeah,
We would like that.
good.
Yeah, I'm speaking and on camera. I know, but when I go to other people's chats, I'm like, oh my gosh, like nobody can see me at all. But do I dare say hello? No, I just lurk. Even in Baker's chat, I'll just be like, yeah, I'm just gonna sit here.
Hey, thanks, George, for coming in and saying hi.
Yes, you can stay if you want to. You're always more than welcome. What's in the corner? I can't tell you.
Where? In what corner?
Because I said I would just go back to my corner.
Oh. Wouldn't you like to know?
Yes. Oh, the amazing acting. It's great. It's great. I hope she is denied as well. I will be keeping my eye out for the written ruling. Pencils. That's right.
Gabby, what
I didn't
the?
hear I didn't hear what you said. Somehow I imagine Shanda is perfectly happy in prison and has driven other inmates crazy with her intelligent brain. You are probably...
You're probably right. I bet you she's gotten her butt whooped a few times. I bet you.
She's tiny. So, okay, we're going to fast forward to last November, where technically her second part of her hearing took place because she didn't come to the courthouse on the first part, and the judge wanted her there. So he had to adjourn that. So now we're here. It's already been delayed. I think at this time, I'm almost an hour into the video because Shanda isn't feeling well, okay? Like, she's sick. All right? You know what? You may be correct. You may be correct.
Maybe?
I'm just looking at her cat, her Maine Coon, Bad Dozer, because those cats are beautiful.
Oh, look at that. Look at that mane specifically. That is beautiful.
Yeah, they are beautiful. I don't know why I paused. I don't know.
Paused
Bobby?
in what sentence?
I don't know why. I don't know.
Bobby, she doesn't have a headache. Stop asking questions. Dang it. Did you not hear? She didn't rip her eyes out today. Okay? We don't want to make her do that.
She's probably well known in the lunchbox. Ooh.
Oh, I'm sure.
Oh, in prison, she perfected her braids. I still want a Matilda. What is it, Crunch Bowl? Was that her Trunch Bowl?
Principal Trunchbull.
Yeah, I want to take her by her braids and do what that principal did to that poor little cute little girl. But I want Shanda to feel it. Maybe she needs an ice bath or 6.
Yeah, you do the thing that she did to the kid, where he like almost hit the fence, but like skidded right over it and like fell into the.
That was a kid. Yeah,
girl.
with the braids. Yeah, but she doesn't get to
Gotcha.
land in the there's no field of flowers in mine when I do that to her. It's like thorns.
Yeah,
big ones.
Rocks, like rocks.
There's gonna be some road rash.
It's basically like the beach down in Southie or something. Broken glass. There's pointy rocks. There's shipwrecks. There's who knows what's over there that you could get, serious
Anything
diseases from.
torturous. I'm sorry. Aw. Well, it was a beautiful cat.
Very beautiful. AJ, razor blades?
Razor blades? Yes.
Why not? Throw those in there too.
Yep.
Probably use needles out there, You're going to find those around the Boston Harbor, I'll tell you that.
That's right. And they're going to, Yeah. Yes, she did. I watched that. We're watching that on Thursday.
She did with better hair. She now seems to Belong to a
to a
gang.
gang.
It's
Haba.
haba, not harbor.
I think my husband's mowing the lawn. So
I can
sorry if
hear
you can-
it. Oh,
it-
I finally can hear something at your house.
Other than a dog.
Yeah. Before we went live, there was fighter jets in front of going around, flying around my house. So all we heard was.
We can only hope so, whoever. And I hope that is a big woman. And
She's probably another
every way.
Prisoners B. Probably.
I hope it is. I think she should only be allowed to buy bread, crackers, and the most extreme hot sauce. And that's
I
it.
bet you there's kind of like the lemon pound cake from what's his face, Afro Man. That police station got so much lemon pound cake. I bet you the prison where she is got
I hope so.
much hot sauce.
I hope so, because I said at the end of her trial, if I could, I would have
Mhm.
sent all of it. Like, I would have sent freaking boatloads, truckloads. Could have came in off the lakes that's up in Michigan. You know, any way to get it there of hot sauce to her and to Paul. Have at it. Enjoy. I hope you forget to wash your hands.
Can only bathe in hot sauce. Yeah. Exactly.
Yes. I'll show you on Thursday. Remind me, and I will show you the bottle. I don't have it. I'll just have to bring a picture of it up. But it's just, it's bad. It's not something that you just would want to consume all the time, that I can't even imagine what it did to his stomach.
Yeah. But especially if that's the only thing he's getting. You know what I mean?
And then you have to keep it down,
yeah.
you know,
Even
so you
though
don't
it's
get in
on
trouble.
a piece of bread, which is supposed to absorb the acid, but all that hot sauce constantly will eventually burn a hole in your stomach. Like it's
Yep.
not a joke. Like the acid from that stuff is serious.
I don't think Paul gets anything. He pleaded guilty, so he's done. He took a deal.
Oh, hopefully he is done.
Yeah. So he's done. He was shocked. That was
Yo, his face, like when he got sentenced, his face, I was like, oh, you didn't think that was gonna happen to you?
He did not. Oh my gosh,
No.
that look on his face was priceless, and it was just
He was looking down like a sad
perfect.
puppy dog, and then when the judge said his sentence, he looked up and with his mouth, he was just like, what?
Yep.
So
Judge
what
saw
is
through
happening?
him. Judge saw through
Yeah.
him. He
Yeah,
certainly
this is a
did.
good judge. Yeah, this is a
Yep.
good judge.
Because he got me. And then, boy, did I get some comments about it. It's like, sorry, I didn't know. But he got me. Yeah, her baby boy had to her boy had to keep it down. She could fake vomit. Yep.
Mm-hmm.
Oh yeah, it was awesome. Flash fan, I'm sorry you don't have water. Hopefully they get it fixed soon. Extreme regret. Is that the hot sauce? I have a picture of the bottle. It's on my phone. Okay, so this is the start of the trial. Shanda doesn't feel well. The judge is entering the courtroom. They're going to talk about it. And I will tell you, her attorney is like, I don't know, dry cereal.
Oh my god.
He
Don't even get me
just-
started with this guy.
It's not the same one.
I know.
But this guy is Mr. Ambrose.
Yeah, Mr.
The good thing
Ambrosia
is,
salad dose.
Yeah. All right, here we go. Also, let me know how the sound is.
All right, before the court is file
Sounds good.
23110 FC. It's people of the state
Thank
of
you.
Michigan versus Shanda Vander Ark. Are you Shanda Vander Ark? All right, Ms.
Of
Vander Ark
course.
appears before the court with her attorney, Mr. Ambrose, Mr. Roberts, as well as Ms. Bloomquist are here on behalf of the people of the state of Michigan. Date and time, the court is scheduled for a Ginther hearing, and technically a continued hearing from the last time we were here. We're delayed. There's been some concerns regarding Ms. Vander Ark's health this morning. Mr. Ambrose, if you want to go ahead and make a record of any concerns you have at this time.
Yes, Your Honor. I had a video conference with Ms. Vander Ark on Friday, this past Friday. It was concerning to me because she didn't appear to be her normal self. And so that concerns me. So I did send an email to the court expressing that an adjournment if possible, just because this is an important phase in the whole appellate process, and certainly of utmost importance to my client that she's able to participate in a meaningful manner. And during our conversation on Friday, it just didn't seem that she was as up to speed or healthy. She expressed some health concerns that she was undergoing at that time, and so that's why I asked for an adjournment on Friday. What I understand is that what she told me this morning is on Saturday she had an episode at the Huron Valley Women's Facility where she passed out for a short period of time, was revived, but she had a medical issue at that time. She's not feeling well today either. I know she was checked out by medical. Her blood pressure is higher than it is normally for her, as she self-reports. So I would be requesting an adjournment. It doesn't hurt the prosecution, I don't think, at all. If anything, delaying this case keeps her in prison. I'd like to move forward if I could, knowing in good conscience that we're putting our
Have any
best foot forward
freaking milk
on a case like
for this
this.
dried cereal man.
100%
I
confident
told
that
you.
my client is able to
He's
participate
dry kind of toast
in
man,
a
I tell
meaningful
you.
manner, and I just don't think at this point I can with any type of confidence say that. So I would still ask for an adjournment, and I know that my client has signed a release for some medical records from Huron Valley Women's Facility to release at least the most recent episode that you had.
Okay, Mr. Ambrose, is she able to speak to you this morning?
Yes.
Not getting into what those conversations are, but are you able to converse with her this morning?
I can.
Okay.
She has a pounding headache, and it doesn't help. It's a stressful situation. I'm sure that's part of the what happens in these types of situations. But yeah, I mean,
as an officer of the court, do you believe she's not competent to go forward? Under the Michigan, under the law in the state of Michigan, do you believe she's competent to go forward?
Yeah, I don't think she's incompetent, put it that way.
Okay.
I mean, she's able to communicate with me, yes,
Okay.
but maybe not at the best.
All right, does she?
Especially with somebody that has a pounding headache. I can
Yeah.
just imagine.
Did she take any medication for
I don't
headache or aspirin or?
I don't think they gave her
Ibuprofen
any medication today.
Okay. Is that something she normally would take for a headache?
Yes. She's
Okay.
She has a thyroid issue. Pointed out to me
Okay.
that it's protruding. She's undergoing testing. Won't know the results for another couple of weeks, and whether it's cancerous or not. If there is a family history of that as well.
Okay. Ms. Bloomquist.
Doesn't have
Thank you,
cancer.
Your Honor. Well, I was going to argue that she's presumed competent until she shows otherwise, but given that's not the claim, then the argument would be whether or not there's good cause for an adjournment, and it's the people's position that a headache is not good cause. Additionally, the people are ready to proceed and put, one, with the Ginther hearing, but
Praying
two,
for a
we do
tumor.
have some evidence that we could set forth to make the record as it relates to her appearance and how she was on the transport on the way here. We did.
What'd you say?
I said praying for a tumor. Just kidding.
Yeah, she don't have cancer. So the guy sitting back here is the prosecutor that we just heard from the 2023 trial that we were listening
Right.
to those questions. So that's Mr. Roberts.
I just want to say thank you to this woman for talking at a, normal pace and level.
I actually put her back down to normal because I had the other guy sped up.
Well, yeah, you have to. But
I do,
even
and
her normal is, it's nice.
It's fast. Yeah.
Have at the after the in-chambers discussion, Jill Medical came and looked at her, and it seems that she's been cleared by them, apart from having somewhat raised blood pressure. So I do think that we could make a record as to why this is not good cause. Additionally, Ms. Vander Ark, through her counsel, did give a waiver of HIPAA so that we could request some records from MDOC. They said that those would be emailed to me in approximately 30 minutes. They were going to do that expeditiously. However, the people would put forth as an officer of the court that in communications with the Michigan Department of Corrections, they would not have transported her had there been a medical issue raised before transport. So, Your Honor, I think this is just, again, another dilatory tactic by Ms. Vander Ark to delay this hearing and to delay the proceedings. And I would say that there's not good cause. And additionally, I think the court can take into consideration all of the prior actions of the defendant, her prior reports, all of that when fashioning whether or not an adjournment is warranted. And it's not in this case, and we should proceed.
Okay. Did anyone, we obviously have the Department of Corrections officers in the courtroom. Did anyone talk to them regarding her condition?
I did, Your Honor. I did inform them they maybe needed to take some brief testimony.
Well, short of that, are either one of you comfortable doing that?
If you would like us to.
Okay, well, why don't we have one, what's your name, ma'am?
Officer Scott.
Officer Scott, why don't you have you come on up and I'll swear you in. What's your first name, ma'am?
First name's Autumn,
Autumn.
A-U-T-U-M-N.
All right, Ms. Scott, can you raise your right hand? Swear it up, and if you swear or affirm the testimony you're about to give you the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, put your hand down and grab a seat. Can you please state your name for the record, spelling your first name and last name?
First name is Autumn, A-U-T-U-M-N. Last name is Scott, S-C-O-T-T.
All right, any objection with me asking some questions, and I'll let you guys follow up. Mrs. Bloomquist, Mr. Ambrose?
No.
All right, good morning, ma'am. I'm sorry you're in this position. This doesn't usually happen. So, my understanding is you transported Ms. Vander Ark here this morning. Is that correct?
Correct.
And where did you transport her from?
Women's Huron Valley in Ypsilanti, Michigan.
Okay, approximately how long is that
About
ride?
2 hours and 45 minutes.
Okay, and now, I kind of understand the configuration. Are you in the back with her in the van, or are you driving in the front? How does that usually work? Where's everybody in the van? Without getting into
It's
too much
okay. I was driving, my partner was in the passenger seat, and Ms. Vander Ark in the back.
Okay, so you were more focused on the road?
Correct.
Okay, all right, so we probably need your partner more a little bit. Now, were you able to observe Ms. Vander Ark?
I can see her through the rearview mirror as I drive.
Okay, was she communicating with you at all?
She only spoke to us a couple times just to ask to turn the heat up or down.
Okay, did she indicate that she had a headache at all?
She did not when we arrived. She did say that she was feeling a little nauseous,
Okay, all right.
a little dry heaving.
Okay, anything from, was it, okay, all right. Did you ask what it was from? Was it from the ride or something like that, or you don't, know?
She did say she does get car sick.
Car sick, okay, all right. To your knowledge, would the Department of Corrections transport a prisoner if they had a concern over her medical health?
No, and if she would have expressed it to my partner, then my partner would have requested to have healthcare come and clear her before we leave.
Okay. Okay, all right. Technically, Mr. Ambrose, this is your hearing, so unless, if you want to go ahead, Mr. Ambrose.
I don't really have any.
Okay, Ms. Bloomquist?
Just briefly, Officer Scott, was she conversational?
She didn't talk much. Like I said, just to ask us to turn the heat up or down for her. Other than that, she was quiet.
Okay. I have nothing further.
Okay, you can stay down. Thank you so much. Do we want to put the other Department of Corrections officer on? Anybody input on there?
I'll leave that in the court's discretion, Your Honor.
Mr. Ambrose?
I don't have an opinion on it.
All right, any other argument before I make a ruling on this, Mr. Ambrose?
Well, just that she did mention that she was nauseous, and that is consistent with, her headache when she reported to me.
All right, Ms. Bloomquist, anything else?
Yes, Your Honor, I just would ask the court to take judicial notice that Ms. Vander Ark, during this motion to adjourn, has actually been assisting Mr. Ambrose in the proceeding with writing notes to him about if she's taken any medication or if she has done anything to assist in remedying her headache. So I think that I just wanted that to be on the record because I don't think the transcript would necessarily catch that, but as an observer in the courtroom, she has been actively participating in this motion through her counsel despite her claimed ailment. So again, I don't think there's good cause for an adjournment, and I'd like to move forward.
All right,
Your Honor, can I just say, just my client writing a couple of notes down, is that supposed to be some sort of active participation? I don't think so.
well, Mr. Ambrose, we're kind of in a catch-22 because I can't ask you what she's been telling you, and what kind of, I can't judge how much she's assisting you without getting into what she's talking about. So I'm observing her writing notes and talking to you, which I've had jury trials where the defendant doesn't say anything to their counsel, and so why don't we do this? The court also has experience with Ms. Vander Ark. Several times during the proceeding, during the jury trial, there were breaks in time where Ms. Vander Ark said she was undergoing distress. I granted those breaks. It seemed to me, and from the outside looking in, that these medical issues seem to be at times of pretty significant testimony in the trial. Not saying that maybe they weren't genuine, but they certainly appeared to be situational. Also, when she were at a preliminary examination down at district court, there was a point of what she claimed to be distress that appeared to be situational. We're here now, and I think it seems to be situational again. Again, she may be going through something, but I understand that adjourning this wouldn't necessarily prejudice the defense. However, there's witnesses here, they're ready to go. People took time out of their schedules. The court set aside the entire day for this. And there is something to be said for the swift administration of justice here. And so, based on this, based on what I have, I don't think there's good cause for an adjournment based on a headache, because that's all really the record's been made. And the only person that can judge if she really has a headache or not, quite frankly, is Ms. Vander Ark. And I don't know if she's telling the truth or not. I have no clue. I will say, as the finder of facts at the trial didn't find her credible, and I don't know how much credibility the court can lay on her statements. So I'm willing to do this. I can take a break, wait for the records to come in. That way the court can review those. I also can offer Ms. Vander Ark, is our jail staff allowed to give her medication, like ibuprofen or Tylenol or something like that? Is that allowed?
I would assume if they discuss it with healthcare at the prison, that would be fine.
Okay. All right. So I don't, do we have something downstairs that she can, I don't know what she takes, Mr. Ambrose should let me know. I'm sure they have it all on schedule. We can do anything we can to help with that. I'm willing to give her, if she needs for blood pressure, I don't know, maybe she needs food or something, I don't know what it is. So anything that can accommodate to help her headache, I get it. If she's got a pounding headache, then I want to at least try to get her some help for that. So why don't we adjourn? We'll wait for the records to come in. Mr. Ambrose, let my staff know if she needs medication, and we can get that from the jail. And then go from there. Anything else before we break, Ms. Bloomquist?
No, Your Honor.
Mr. Ambrose?
No, thank you.
Okay, we're in recess.
Judge doesn't believe her. I love it. Yeah, we don't need to hear your music. All right, give me a sec. Now we gotta fast forward. And I can't see. Oh, I can see those a little bit better. Bonk. All right.
110
Right.
FC.
There we go.
People versus Shanda Vander Ark. Mr. Ambrose, did your client, was she able to get some medication or no?
No, not yet.
All right. I know there's some bureaucracy stuff that goes on between the
Yeah.
jail and,
The MDOC is the one that would dispense it, since my understanding, because she's not in Muskegon County custody, that it have to go through MDOC. So I did send an email to the person in charge of the MDOC, who would be the person that could authorize at least some medication.
how is her headache now?
Not good. I mean,
All right. All right, I did get a copy of the medical records. I'm assuming that we don't want to make those a part of the record, at least certainly not an open part of the record. I guess, how do you guys want to proceed with that? I can make them a confidential part of the record?
I would stipulate to any sort of protective order that the defense would want on these matters.
Mr. Ambrose?
that's fine.
Okay, so I'll make them part of the record. We'll call it the court's exhibit number 1. It'll be a confidential record. The court did have a chance to review those records. It looks like on the 22nd, without going into all the details, it's like on the 22nd, Ms. Vander Ark complained of that she felt like she was going to pass out. I don't think there's any indication in these records that she did in fact pass out. There was some concern with some thyroid issues when she was eating apples, I guess, and they basically told her, don't eat apples. That's what's in the records. So there's nothing in these records about her actually losing consciousness. She reported that she was going to pass out. There's also indication that she asked for some Dramamine for the trip to Muskegon because she typically gets car sickness. So that's kind of in line with the testimony that she felt sick on the way here, but she at least indicated that she gets car sick. So,
Boo-hoo. Sicky, she and her older son, she and her other son, starved, abused, tortured her 15-year-old son to death. He weighed 69 pounds at the time of his passing, died from severe malnutrition, severe dehydration, and hypothermia in July because she left him in an ice bath, I think for like 7 hours. Really bad stuff. Now she's trying to get a new trial because she didn't like her defense attorney, apparently. He did nothing wrong. Not that I'm a lawyer or a judge. I don't see what he did wrong. I don't see that he did anything wrong. But we're going to hear from him in a minute.
unless I'm missing something, it sounds like they sent her because there was no concern. So based on the records and what we've already done here, I think she's competent, and we're going to move forward today. I am concerned that she reported losing consciousness when a medical person indicates that she complained of feeling like she was losing consciousness, and that she's now kind of amplified for whatever reason, I don't know. But I am concerned about that, the fact that she misrepresented that to her attorney, potentially, that she actually lost consciousness, because there's no record of that in the plea. So anyway, anything else before we move on, Mr. Ambrose?
Well, the only way that, she would have to report to the medical personnel that she actually did lose consciousness. So,
Well, I mean, she okay. I get it, but the quote is, quote, "I felt like I was going to pass out. I have tremors that are severe." That's what she reported on a visit November 22nd, 2025 at 6:45. And she was treated. She says the administrative note was that she was advised on site that the above patient came to the clinic concerned of dizziness and a tingling throat. The tingling throat was transient and only when she ate apples. And it says the RN advised patient had a reddened throat, no swelling, no lymph node enlargement noted. And eventually the treatment is, it says she did palpate in a large thyroid. However, the patient is, I don't want to get into that. It says RN still had concerns about patient's fall risk. The RN exam otherwise unremarkable. RN gave the patient detail prior to calling. I advised RN to tell the patient to stop eating apples. Other than that, I did not have orders for this patient. So that's what happened on the 22nd, at least according to the note. Like I said, I don't know what happened, but these are medical records by individuals that I don't know if they have a reason to lie, quite frankly, if they're making a medical record. So based on that, I don't see a serious medical issue that is to the concern of the court. So anything else, Mr. Ambrose, on that? I mean, she can testify if she wants about what she's going through. That's fine, but if the request is for an adjournment because of a medical issue, I don't see it, so. Well, I'm not, listen, I'm not gonna delay this anymore. This is, in my opinion, Mr. Ambrose, she's misrepresented and through you to the court that she passed out. She did not pass out. So I'm moving on. I think this is gamesmanship on her part, and it's now 11 o'clock on a hearing that we were supposed to start at 9 o'clock. The court's been very patient with this, and we need to go. So, anything else?
No, Your Honor.
Ms. Bloomquist. All right. So, Mr. Ambrose, this is your hearing.
Yeah.
You can call any opening statements on either side, or you want to just go straight into witnesses?
We can go straight into witnesses.
All right. You can call your first witness.
So we got Mr. Johnson.
Okay, so this is her attorney that she had in her trial that's getting ready to come up to the stand. I'm going to speed them back up a little bit because they both speak very slowly. If I need to slow it down, I will, but it won't. I don't even think you'll notice. So, but just letting you know. And this guy's super nice. I think he did the best with what he could.
All right, Mr. Johnson, if you want to come on up front here, sir.
For those of you that don't like defense attorneys, I just tell you this. Listen to what he says about what his thoughts were on this trial and her case. Because it'll just show you that they are doing their job as they should, but they know. They have pieces of crap that they're defending sometimes. Sometimes they are innocent. She's not. It's on video. She was dumb enough to tape it, to take video of it. So
it's in text message. It's on video. It's all over her face. It's in that fake basket that she fake threw up in.
Yeah. But I get especially defense attorneys have really bad reputations, but I'm telling you, like, this was telling what he says. So, that's all I got.
Good morning.
Good morning.
All right, would you raise your right hand to be sworn?
Yes, sir.
Matter now pending. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, put your hand down and grab a seat. Please state your name for the record, spelling your first name and last name.
My name is Fred Johnson, FREDJOHNSON.
All right. Mr. Ambrose, you're welcome to stay at the table or the podium, whichever you prefer. So you can stay standing, stay sitting, it's up to you, okay?
Yes, thank you. Mr. Johnson, you represented Shanda Vander Ark, is that correct?
That is correct.
Okay, and do you recall, you're an attorney,
Yes, sir.
Can you tell us when you became an attorney?
1984.
You know, and I apologize, Your Honor, before we start. Ms. Vander Ark, Mr. Johnson may be getting into some confidential information. You understand that?
Yes, sir.
And you understand that by going forward with this type of hearing, that he's going to relay some confidences.
Yes.
Are you okay with that?
Yes, sir.
Do you have any questions regarding it?
No, sir.
Okay. With that disclosure, Your Honor, I'm going to proceed with the
Okay.
examination.
Anything else we should put on the record regarding that you want, Ms. Bloomquist?
No, Your Honor.
Okay, all right, good enough.
What year did you become an attorney?
1984.
Okay, and where'd you go to law school?
Thomas M. Cooley.
And so from 1984, have you always practiced criminal law?
I have always practiced law. Yes.
Okay, and has your license, have you continuously been an attorney ever since 1984?
No, sir. My license was suspended last year for 6 months.
And what was that? So it was suspended last year for 6, what was the reason why it was suspended?
Violation of confidentiality, conflict of interest rules.
Okay, and that was while you were a public defender?
Yes.
And when you represented Ms. Vander Ark, you were a public defender, is that true as well?
Yes.
And the initial allegation that was lodged against you, when does that go back to?
Oh, gosh, that was, I couldn't tell the year, 5 years ago, perhaps 6.
And when was the complaint issued against you?
2024 is my guess.
Okay, and
2023 perhaps.
Did you admit to the grievance?
Yes, I did.
And what did you admit to?
I admitted that I had received information from one client while representing another client, and the person who the information I received was the victim in that case, in the second client's case.
And again, this was while you were the public defender?
Yes, sir.
When did you take on that role?
2013,
And
September.
what did your office consist of
In 2013,
throughout the years?
it grew over the years.
Okay.
We started, I think, we're at 13, and by the time I left, we were in our 20s, maybe 25, 26. And
Okay.
that includes staff as well.
So you mentioned that you admitted to the allegations within the grievance,
Yes, sir.
and what did you have to do as a result of your suspension?
I was suspended for 6 months, so I could not practice law. There's a fine and costs.
Were you required to take any type of classes?
Was I required to? No, I did. I was not required to. I did, but I was not required to.
What type of classes did you take?
On ethics, conflict of interest.
Okay. And did you testify at any of these hearings?
Which hearings? The ethical issues hearings?
Yes.
Yeah. I don't know if it was testimony or not. I made a sworn statement at the time of my initial interview, and I spoke to the state bar, and I think that was under oath as well, so that both my participant testimony.
Okay. And part of your disclosures were that you're more or less overworked. Is that accurate?
Was I overworked? I think I was.
And would you disagree with I was working too long, I was working too many cases, too much stuff, too many irons in the fire. Is that something that you may have said?
Yes, sir.
Any disagreement about that?
No, sir.
Also, basically, when I was a public defender, I was working on a conveyor belt system, and the problem that came up on the belt next is the one I tackled and tried to keep the other ones juggling until I could fix them as well. Does that sound like something you might have said?
Yes, sir.
Now, this case with regard to Ms. Vander Ark, do you recall when you initially, how is the assignment system conducted in Muskegon County?
You mean back then or now?
When you were assigned?
When I was public defender?
Yes.
Okay. The attorneys are assigned to judges, and whatever case the judge received, that attorney assigned to that judge will receive that particular assignment. Normally, that was the situation, unless something came up and then we'd have to change assignment for whatever purpose might have occurred.
Is there a private bar that receives assignments as well, or is it just everything that every indigent client goes through the public defender's office?
Things have changed over the years. Things have changed over the years. Currently, all the indigent individuals go through the public defender's office. There is a private bar, however. Are there assignments to the private bar? On occasion there are, and there were.
Upon receiving the assignment, do you recall when you would have first talked to Ms. Vander Ark?
I would assume it was before the preliminary examination, but I don't have a specific recollection of any particular dates.
At any point in time at the preliminary examination, with your initial conversation with Ms. Vander Ark, did she ever admit to any type of guilt?
No, sir.
All right. Now, she contended that she was innocent throughout this case, isn't that right?
Yes, sir.
She testified, right?
Yes, she did.
She never admitted to any type of wrongdoing that caused the death of her son.
That is correct.
Now, while you were assigned to the case, did you have Ms. Vander Ark see a professional with regard to competency or criminal responsibility?
I had Ms. Vander Ark see several professionals, 2 doctors, and we employed social workers on our staff.
With regard to, do you recall having Ms. Vander Ark seen by Colin King, Dr. Colin King?
I do recall that.
And report, did he do a report?
He did.
And do you recall what the results of that report were?
I don't recall the specific results. I recall the conversation we had in regards to that report.
As part of his conclusions, would you agree or disagree that he mentioned that Ms. Vander Ark continues to insist she did nothing wrong and was not convinced that her actions and instructions caused the death of her son?
I don't recall that specifically. The other report, it might refresh my recollection, but I don't argue with that statement. It sounds, generally speaking, is what I recall.
May I approach the question?
You may. Yes, sir.
And that is, it's an accurate statement that she had stated that to this doctor that she felt that she did nothing wrong. Is that correct?
Yes, sir.
And you went to trial on that basis, right?
We went to trial because she was charged, sir.
And she proclaimed her innocence, right?
Even had she not proclaimed her innocence, we would have gone to trial and she was charged with first-degree murder. But yes, she proclaimed her innocence from beginning to end, and we tried the matter.
Were there any offers made to Ms. Vander Ark?
Not that I can recall. Sorry.
Now, Ms. Vander Ark testified at trial, right?
Correct.
And she again proclaimed her innocence to the charges, right?
That is correct.
And there was an incident on the day of her testimony where she had a physical reaction to seeing a photograph of her son. Do you recall that?
I believe that was, if we're talking about the situation where she turned and there was a trash can there and she appeared to I don't know if she actually did vomit, but she had the body language was indicating that's what was going on. I was sitting in the chair there with the prosecutors.
And during her cross-examination was, you described the cross-examination for us.
Aggressive and effective.
Okay, aggressive and effective. And did you see Ms. Vander Ark after court that day?
I don't believe I went out to the jail to see her after court that day, no.
Okay, did you go into lockup with her after court?
I can't honestly tell you that.
Right. The next day, can you tell us what happens?
And if my recollection is correct, the next day, court was resumed and my client, Vander Ark, was unable to attend. She was unable to come to the hearing, as I recall.
And you reported that to the court, right?
Yes, sir.
And you stated to the court that she had some competency issues at that point, is that correct?
Some competency?
That she wasn't able to proceed.
Yes, and yes, sir.
May I approach you? And this is, I'm showing you a transcript of December 15th, 2023. It's on page 3. If you can just read that portion.
Yes, sir.
And so you indicated to the court that she wasn't competent to proceed, is that right?
That is the word I use, sir.
Okay. And describe to us what she was going through.
She was, when I went to visit her, she was curled up in a ball on the floor. She was crying. She was upset. She expressed that she couldn't return to court. She expressed that she was upset, that she was stressed, that she was experiencing, and I'm sorry, I forget the word. She's experiencing a period of where she's so emotional she can't function intellectually.
And based upon that, you reported that to the court.
Yes, sir.
And you also, do you recall reporting to the court as well as that if we waited until, or adjourned the matter until Monday, Tuesday, or Wednesday of the following week, we'd be in the same situation?
I don't recall, but I'm not arguing with that. I assume the intention was there. I don't recall saying that, but.
If you look on page 4.
Which paragraph, sir?
The second full paragraph,
Okay.
starting with the word 1.
Okay.
And you agree that you told the court, we couldn't guarantee to the court that as of Monday or Tuesday or even Wednesday of next week, we'd be in any different situation than we are right now.
That is what I'm saying.
And was that an accurate assessment?
That was my assessment at the time, yes, sir.
Do you, okay, so one of the things that you argued to be, or suggested to the jury was that Ms. Vander Ark was guilty of manslaughter. Is that right?
That she was guilty of manslaughter.
Yes.
I don't know if I used that term. I don't recall arguing on the manslaughter issue. Can you tell me, Trey?
Yes. I have this broken up, but it's on page 84.
Okay. Do I have it?
Yes, in the back.
Okay. We're also in 84 council.
It's actually on the very last page, page 80.
Okay.
First full paragraph. And you told the jury, these people, and I'm assuming you meant Paul as well, these people committed manslaughter. That's what they did.
Yes, sir.
They caused the boy's death. That's
Yes, sir.
interesting. Now, Ms. Vander Ark never gave you consent to say that she was guilty of anything, did she?
No, sir.
And so you kind of took it upon yourself to make that argument to the jury.
Yes, sir.
I have nothing further.
Good morning, Mr. Johnson. How are you?
I'm well, thank you.
So I'm just going to go back a little bit more into your experience. How many years have you been a practicing attorney?
41 this year.
Okay. And how many years of that as the chief public defender for Muskegon County?
From 2013 to 2024, so 11 years.
Okay. Is it fair to say in your role as the chief public defender, you would take some of the more severe cases that the county has seen?
Yes, sir.
Okay.
Yes, ma'am. My apologies.
That's okay.
I'm on the roll.
Now, just sort of getting into some of the comments that were brought out from your sworn statement or things like that, there's discussions about your workload. Do you recall that? And maybe feeling like you had a conveyor belt system.
Yes, ma'am.
Did a case like this fall into the same category of cases you were discussing in that?
No, the cases like this get the spotlight. They come out of a group, of a pack, and we place not only my efforts, but the social workers and other attorneys on staff. We all work on cases of this magnitude.
Okay. So although there's testimony by you to the effect of being overworked and that impacting some of your cases, is that an accurate sort of representation of what's said?
It certainly impacted the one where I saw that information. I should have seen it. It impacted there. That's why I think that. But I'm sorry. Go ahead.
No, and that's okay. And just to be very clear, the case for which you had your suspension had absolutely nothing to do with this case, correct?
That's correct.
No witnesses between, Paul and Ms. Vander Ark. That wasn't the conflict at issue.
That's correct.
Okay, it was a wholly unrelated matter.
Yes, ma'am.
And, while we're on that topic, did you have to sit in that exact same witness chair in a Ginther hearing on that case as well?
Yes, ma'am.
Okay. And you testified about the allegations and the conflict that was alleged?
Yes, ma'am.
So getting back into your prep on this case specifically, let's walk the court through your preparation for trial. Let's start with prelim. Walk us through your preparation for preliminary examination on this case.
Well, I assume all lawyers do. You receive information called discovery, and you pour over it. You go out and see your client, you talk to your client about what's going on and what her impressions are. You come back and you go over it again. You bring in other attorneys to take a look at issues. You run issues back by them, see if they have any similar experiences or any pointers that they may want to bring to bear. You bring another attorney in, usually a younger attorney, to sit and to watch the whole process. We also employ interns here, so the beauty of interns is, whereas I may have multiple cases, they only have the one, and they pour over the documents and the materials, and if there's anything in there that they see, then they can bring it to my attention. But it's a fallback situation, so we can bring other eyes on it. And there was no different than here, Ms. Vander Ark. We did all these things. We worked dozens of hours just for the preliminary examinations, and we were ready to go.
So it sounds like you created a team, so to speak, for Ms. Vander Ark.
Yes, ma'am.
How many people would you say were on that team?
Over time, coming and going, over time, from the time we got the case to the time we ended, maybe 4 lawyers, an investigator, 2 or 3 social workers, so we're up to 9, and half a dozen interns, so about 15, 16, something along that line.
So 15 or 16 people working on her case specifically?
Over the course of time, yes.
Okay. And as part of your preparation for trial, now let's shift to preparation for trial. You talked about hours for preliminary examination. Could you describe to the court your preparation for trial?
At this point, we've had time, a year, to look at this thing. We've brought in experts to examine my client. We've gone out to the scene of the crime and taken photographs and walked around, got the feel of the place. We've talked to multiple folks who we were considering experts, but we ultimately didn't hire. We spoke to outside social workers to see if any of them had come across any episodes along the similar line. We even saw an article in People magazine about a woman who thrown her kids out the window and then jumped herself. And quite frankly, it was eerily similar. And I think I'm still convinced there's something to do with what my client's conduct. But it was hundreds of hours by then. And I'll put in a couple hundred hours myself on it, and then you add in what everybody else is doing. It's a lot of time. It's a lot of effort. And I told her I think that she had to hire, spend $1 million on what we did for her in terms of trying to prepare and defend her on this case.
So just so I'm clear, you yourself dedicated hundreds of hours
Yes, ma'am.
Personally to this case?
Yes, ma'am. It was either I'm reading something or I'm talking to somebody. I'm looking for this needle in the haystack. I believe then, and I believe now, there's something wrong with my client, and that there's somebody out there who would be able to tell me what it was. And I still do that to this day.
So I want to dive a little bit deeper. You said that you sought out experts, correct?
Yes, ma'am.
And were some of your experts from the Center for Forensic Psychiatry? The sort of state-run?
We use the appellate defender has a website, and they have a listing of witnesses, expert witnesses that other lawyers have used, and we use their list in determining which ones to approach. We also use, here, from the other lawyers in the office, have you used anyone in these circumstances? Do you know of anyone? And those are the lists we use.
Okay. And so, I know the record will reflect this, but I want to ask you, do you recall having a criminal responsibility report done for Ms. Vander Ark?
Yes, Dr. Watson.
And do you recall also having a criminal competency report done as well?
Yes, ma'am.
And now those were ones that I believe were filed with the court, correct?
Yes, ma'am.
Were there reports that you, or examinations that were done and reports that were drafted that were not filed with the court on Ms. Vander Ark's behalf?
I don't know if we filed Dr. King's report or not. I don't think we did.
Okay. And did you also get a report from a George Watson Jr.?
Yes.
Okay, and to your knowledge, was that ever provided to any, to the court or to the parties?
To my recollection, no.
Okay. Is it fair to say that you did a lot of investigation into experts who could testify about her mental state?
I think that is fair.
Why didn't you present those experts?
The conclusions the experts provided would have been supportive of a verdict of guilty of murder. Their positions were uniformly and enthusiastically negative towards my client. They would have been prosecution witnesses and presented their findings.
So you intentionally did not call these
That
experts?
is correct. We intentionally did not call them.
And that choice was made after a thorough investigation of their opinions, correct? Or I guess explain the investigation that went into that determination.
Dr. King, for instance, when I spoke to him, his response was, she's a monster. His response was, she's the worst thing he'd ever seen. And he's a man who testified for mass murders. I did not want to bring his testimony. Dr. King simply said that she was competent at the time, she was competent for trial, and he had no, and that's not what I wanted the jury to hear. I want the jury to hear there's something wrong with her.
So let's get into, and I hate to zoom out here from these details, but what was your overall strategy?
The overall strategy was to attack the issue of premeditation. That my client premeditated when she caused the death of this young man. Our strategy was to demonstrate that through, especially her text messages, that she was, for whatever reason, unaware that her son was suffering and was close to death. And we tried, especially with her text messaging at the time, to demonstrate that that was the case.
And I know you previously said you were looking for a needle in a haystack for something in your defense, correct?
We were looking for the cause. If you understand the facts involved in this case, this young man was her son. This young man, she could have refused him. She could have refused even to take him into her home. She brought him into her home to care for her. This young man was killed in the most brutal, heinous way that you can imagine, slowly starving him to death. The two, and it probably is just because that's the way I just can't believe that a healthy person would have done the things that she did. I don't believe it to this day.
Now, the realities of this case and the nature of it is something you have to factor in your preparation, correct?
Yes, ma'am.
And you did, in
Yes.
fact, do that?
Yes, ma'am. The evidence? Yes.
Okay. And now you've talked about these hundreds of hours. Have you also, in preparation for this trial, did you engage in witness preparation?
Of my client?
Of anybody?
Yes, we talked to my client about her role and how we were going to decide once we got there if she was going to testify and the sorts of things she might be asking, the sorts of things that we'd be asking of her. Our only other witnesses would have been the experts had they been called. And so there wasn't anyone, or the social workers. And since we didn't call any of those folks, it wasn't necessary to prep any other witnesses for testimony.
And additionally, in preparation, did you evaluate filing motions to suppress or other sort of pretrial motions on this case?
Certainly. And that was the value of the group thing. You have several lawyers and you're asking them, and an investigator, what about this issue? What about that issue? Should we file a motion on it? Should we attempt to take it to the Court of Appeals if we lose, that sort of thing? All those issues were discussed.
Okay. Did you also prepare for your voir dire in this case?
Yes, I did.
Are you aware there's an allegation that you did not prepare for voir dire in this case?
Yes,
Okay, and in preparation for today's hearing, did you provide to me some documentation from your file regarding your voir dire?
I did.
Okay. Your Honor, would you like the people to be numbers or letters given today's proceeding?
Let's do numbers. We'll stick with consistency, unless someone's pre-marked exhibits, but we'll do numbers.
Okay, I'm going to be showing, may I approach?
You may.
All right, I'm showing the witness what's been marked as People's Proposed Exhibit 1. Could you identify what this is for the record?
Yes, this is my standard voir dire sheet, in which 4 pages of questions that I may or may not be asking, depending on the nature of the case. But certain things that I want to make sure I cover and ask the juror or potential juror before they're seated.
Okay. Do you recall if you used this preparatory document in your trial?
Yes, I did.
Okay. And I know this is a blank version, but did you take notes on it during the trial, or?
Yes, I did.
Okay. Your Honor, at this point in time, I'd move for the admission of People's Exhibit 1.
Mr. Ambrose?
I'm sorry.
There's been moving for admission.
Oh, I
of
didn't
Exhibit
know.
1. All right, so Exhibit 1 is
We
admitted.
can just leave that on there.
Without objection.
What did you do to prepare for voir dire? Was it all contained in this document, or what else did you do?
No, ma'am. The day before, a couple of days before a jury trial, the list of potential jurors are made available to the parties. We got that list, and there's some information, used to be better once handwritten, but now the computer stuff is not as helpful, but there is information, and we, and I say myself and the interns, go over this information to discuss potential jurors. We're looking for folks that we want to keep on the jury and folks we don't want on better. And so we're going over these things, and we're asking questions back and forth. Do you know these people? Have you met these people? Are these people, are they friendly to us? Will they be hostile to us? And we're going over that list. And so we've got notes. When we come into court, we have notes on the witness list that they gave us as to individuals we may not be called, we may not wish to have on the jury. A police officer. If there's a police officer, we're probably not asking him to remove or her to remove. So we go over that. Then when we get to when we prepare, we're looking at which of these questions are important to us and which ones are not. The way voir dire works, as you know, they're asked, did you hear all the questions and would you answer any different? So you can't ask the same questions over and over. So what I try to do during my voir dire is specifically save out some questions so that every time I take somebody out, I have new questions for them. The whole panel hears them, but they're new questions, and they kind of help keep the interest of the rest of the panel. So that's part of the voir dire preparation. The reality with voir dire is, if you pick a bad jury, the case is over. You're done. You've gotta emphasize that part, because if the jury's not listening to you, it doesn't matter how brilliant you are afterwards. The voir dire has to be effective for your client. So we put a lot of emphasis on it.
And you specifically did in this case?
I specifically did in this case.
Now, is also part of your voir dire come from experience?
Yes, ma'am.
And could you give a rough estimate before this trial how many jury trials you have conducted?
Misdemeanor, misdemeanor and felony, maybe 2 or 3 a year, felonies, and back when I was, before I became a public defender, 10 or 15 misdemeanor cases, literally couple hundred. I don't know. I've lost track a long time ago.
You don't keep a sheet with?
Yeah, at least 10, 15 a year for 30 years. So.
Okay, thank you. But you have vast experience in selecting a jury, correct?
I've done it many, many times.
And is part of selecting a jury knowing potential jurors out in the gallery that might be called up if you excuse somebody?
Yes, ma'am.
And I guess, do you see your obligation as a defense attorney to make sure you use every preempt, or to make sure you get the best jurors seated in those seats?
I want the best panel, and I will. I tell my folks, that, young folks, it's not how many questions you ask the right questions. You don't need to ask 100 questions. So there are occasions when my voir dire may be brief, but it's hopefully is effective. And I'm talking, and as Judge Casey will say, I talk loud. Everyone in the courtroom can hear me when I'm doing my voir dire. I speak to the people out the back as well as in the panel. So yes, I'm aware of the panel here, but I'm also aware of who's sitting out there in the jury. Sometimes taking a person off the jury doesn't mean you're going to replace them with someone better. That's the Detroit Lions philosophy. Just because you replace somebody doesn't mean they're going to be better. Sometimes once you got the best you have, you stop talking.
Did you feel like you had a good panel in this case when you concluded voir dire?
Every lawyer says, I want a fair jury. We don't. We want a jury that's going to do what we want. I want a jury that's going to say not guilty. I got a jury as close to that as I was going to get from this panel.
So I'd like to shift a little bit and move into your interactions with the defendant. Do you recall, and it can be approximate, how many times you met with her personally?
Gracious, no. I couldn't meet with her, well, okay, meet personally. Gosh. No, it was, I tried to go at least every other month, so we had a year, maybe 6 times, maybe. And then during trial, gosh, and then after trial, and then are you counting the time after trial when I went to Jackson to meet with her?
Well, let's
Or just before trial?
let's say before trial,
Okay.
but then I'll get into the Jackson.
Half dozen, somewhere between 6 and 10, something like that.
And that was while she was lodged at the Muskegon County Jail?
That is correct.
Okay. How did those meetings go? What was the general atmosphere?
The meetings went very well. Notwithstanding what she was convicted of, Ms. Vander Ark was a wonderful client. She was a client from heaven. We talked. Her conversations were on point. She used time well. She didn't keep me after the point of the visit was over. She asked the question. She responded well. We have a wonderful attorney-client relationship.
And so it sounds like she was a cooperative
Oh,
client.
absolutely, always, always.
And she had, would you say, above average understanding of the proceedings and what was coming with the trial?
She's a lawyer. She went to law school. She graduated from law school. She has one question on her bar examination. She clerked for 2 judges. She must have sat in on a dozen felony murder cases, sat in and watched them. So she had as much experience with the law as somebody who has never practiced could possibly have. She was, and our interactions were tailored towards that. It's not one cookie cutter for every client. Her situation was different. She could understand and put together the facts and circumstances in a way that a layperson couldn't do. And that was very effective for her and very, I appreciated it.
And in those discussions with her, is it fair to say you discussed trial strategy with her?
Yes.
Okay, what was that trial strategy?
The trial strategy initially, and hopefully when we began, was to find that there was no intention, there was no premeditation, and that there was something mentally wrong with the person that committed this offense. Quite frankly, and I would tell my folks when I first met them, in the first 6, 7 months we worked on this, I would tell them there must be somebody else living in that head along with her, because the person I knew and the person who did these things, they just didn't know. So our hope was to find somebody who could put a finger. This is what she has. This is what's wrong with her. When that didn't bear fruit, we moved to, okay, when did she perform? When did she create the intention to even injure her son? Because our argument was she never formed it.
Did you discuss manslaughter with her?
Yes, manslaughter, murder in second degree, all the all the homicide crimes, we discussed each and every one.
And you read portions of your closing argument.
Yes, ma'am.
And did you discuss with her about conceding manslaughter in your closing?
I don't remember that.
Okay. Why did you concede manslaughter?
The volume of evidence and the type of evidence was massive. And if you look at a jury and you tell them that nothing's wrong when it's clear to even somebody has made attention that something wrong's happened, you lose them. And when you lose credibility with the jury, they never listen to what you have to say after that. Quite frankly, I was hoping for murder too. I told them manslaughter because that would give them the space to move up. But I was hoping that they would see me as a fair dealer, as an honest person who looked them in the eye and told them, this is what's going on, and I'm not going to try to lie to you or put up lawyer tricks and fool you with the gun. That glove doesn't fit it, you must have quit that stuff. I'm an honest guy, this is what I honestly think, and this is why you should think it. So I had to concede something because, quite frankly, the evidence was overwhelming, and the prosecutor hadn't even put in his best evidence.
And at the time of closing argument, is it fair to say that Ms. Vander Ark was not assisting you in your closing argument, given her mental or physical state in the jail?
We had, before the day that morning, we had stopped talking about what we were doing in court, and it was just conversation of, will you come to court? That's all we talked about. Will you come to court? And when she couldn't, then we went back to court and we finished up. We had talked about the things I would say, generally speaking, during the course of my representation of her. But the reality is, a closing argument is as much art form as in science. I don't know exactly what I'm going to say every time, so I couldn't tell her exactly. She understood the plan. Did she know exactly what I was going to say? No, because I didn't know exactly what I was going to say.
But I want to just clarify, though, your decision to concede manslaughter wasn't an off-the-cuff decision.
Oh, no, it was not. No, it was not.
And you conducted some investigation, and you put a lot of thought into doing that, correct?
Yes.
Okay. So I want to shift gears here into her competency. How many cases have you handled where someone has been referred for competency or criminal responsibility examinations?
3 or 4 a year, so 30 or 40.
Okay. And so have you had situations where you have somebody who absolutely can assist you in any aspect of the court proceeding?
Yes.
Was that the case in this case?
No.
Okay. And during trial, was Ms. Vander Ark alert to her being Ms. Vander Ark?
Yes.
Was she alert to, she was in Judge Casel's courtroom?
Yes.
And that it was the date and time that it was that year?
Yes.
Okay. And she was actively assisting you, it sounds like?
She was.
Okay. And was she assisting by writing notes while you were at counsel table?
Yes, and that was what I do is I can't listen to the witness chair and my client at the same time, so I give them a pad and pen and ask them to write notes despite the votes.
And without getting necessarily into what she was writing, was the content of what she was writing coherent?
Yes.
It was attuned to time and place?
Yes.
It was appropriate for what was going on in the courtroom?
Yes.
Okay. So let's talk about Thursday after she testified. Now, you don't recall if you went into the holding cell or the jail with her after the testimony concluded?
Okay, let's make sure I understand.
Yes.
When trial was over, did I go into the jail? Okay.
Thank you for clarifying. That was
Okay.
a poorly worded question. When the proceedings on Thursday, not the last day, but the day she concluded her cross-examination,
Yes.
when that day concluded, did you go to the jail to meet with her?
I believe I saw her in the holding cell, which is back here behind the jury room. I think after each day, myself and the social worker involved, we go back and we talk to her for a few minutes, but then we break. That was the plan. Did it always happen every day? I don't remember. I think we did most days. I don't know if we did that day.
So you wouldn't be able to say how she was appearing outside of the courtroom after that?
I have no recollection of her after she walked out of the court that day. Then I don't recall.
Okay. So let's move into that Friday morning
Yes, ma'am.
that you've already testified about. And you described that she was in a holding cell, correct?
Yes, ma'am.
Do you recall who was in the holding cell with you?
My Ms. Vander Ark and my caseworker. Who's my caseworker? My social worker was there. I'm trying to remember which one it was. No, I don't remember which one.
Would it be Melinda Katecki?
Yes, yes, that was Melinda.
Do you remember a couple of jail deputies also being there?
They were in the area, but they weren't in the cell. There's a cell area, and they stand outside of that. They weren't in the cell.
Okay, so to your recollection, it was you, Ms. Katecki, and your client?
That's my recollection.
Okay. And you indicated that she was on the ground curled up?
She's on the floor, curled up against the wall.
Okay. And could you tell the court what your conversation is with her, like at the start of that morning, when you first walk
Okay.
in? What's the conversation?
Are you okay? What's going on? Can I get you something? What are you feeling? Can you explain to me what's going on? What was the situation? Ms. Kotecki was also talking to her the same sorts of questions. What's wrong?
And what did Ms. Vander Ark reply?
Effectively, I can't quote her, as she said. Her response was that she could no longer, she could not go up into the courtroom today. She couldn't take the trial today. She was having an episode, and she just couldn't tolerate being in the courtroom today.
Okay. And at some point you come up to the trial court and you place on the record
Yes.
what occurred, correct?
Yes.
And in that you stated you discussed Ms. Vander Ark's options, correct?
Yes,
Did you in fact discuss her options on how to proceed that morning?
yes, yes, ma'am.
Could you explain that conversation to the court?
We explained to her that option one was to come back in the court and just sit there. We're going to stand again today, just sit there. Option two was for us to go back and ask the judge to adjourn. That was in fact plan A, to ask for an adjournment to give her, or at least some breathing spell. When this happened a time previously, the judge gave her 5 minutes, but we already had an hour or so in on this thing, so we're asked. So that was plan B. Plan C was to continue to represent her. If the judge said go, we're going to go.
Did Ms. Vander Ark want the adjournment?
Yes.
Did she want, and if the adjournment wasn't available, I guess, did you discuss waiving her right to be present at court?
I don't think, I don't recall. I don't think I did. I don't think I told her that she had a right to refuse.
If she signed an affidavit saying that she is voluntarily choosing not to come to
Oh.
court, would that refresh your recollection?
It does, you're correct.
Okay.
She did sign an affidavit.
Okay. And did you know that that was happening, or were you aware that that was something that was being drafted for her to
Yes,
sign?
yes, I was.
Okay. And so, does that refresh your recollection about the conversation?
Yes, it does.
Okay.
Yeah.
Now that your recollection's refreshed, do you recall explaining to her her ability to waive her presence?
Yes, I remember, in the context of the affidavit, I think we came up and came downstairs a couple of times. And when we came down and said, this is what's going to happen, you have this, if you don't want to be there, you have to let us know, and she signed an affidavit to that effect.
Did you coerce her in any way not to come to court?
Okay.
Okay. Did you want her to come to court?
Yes, ma'am.
Would that have been better for your case if she came to court?
It would have been better, yes, ma'am.
Did you feel like she understood what was happening to sign that affidavit?
Yes, ma'am.
Or at least to make the choice to not come to court?
Yes, ma'am.
I apologize, I shuffled my notes here. Now, when you were asked about using the word competency, I believe it was on page 3 of that transcript you have there, you said, well, that's the word I used. Could you explain your response to that question?
I used it in the layman's vernacular as competency, not as in the legal standard as competency. I didn't mean that she, as lawyers know, that she couldn't participate or that she couldn't understand. I didn't mean, I meant as a layman would use the word competency. She just wasn't ready to go. She wasn't able to write me those notes or whisper in my ear or to participate as I would want her to have. Her life's on the line. It's a murder trial. I want her to be fully able, I'm going to say competent again, to participate in the process. This is her chance. This is her chance. And I didn't want her to leave that courtroom thinking that she left cards on the table or whatever the expression might be.
So it was not your impression that she was legally incompetent the morning of that Friday morning?
That is correct.
Now, had Ms. Vander Ark, and I know the court's referenced this before, but Ms. Vander Ark had episodes before, correct?
In my presence, she'd had, if we're not talking about when she saw the photograph, in my presence, she had one episode, but she expressed to me during the course of our representation that she'd had others.
Okay. And one of those episodes, and correct me if I'm wrong, but you observed the episode at the preliminary examination where her co-defendant was called to the stand and she had an episode, correct?
I don't remember the timing. She had the episode of the 3 minutes.
Okay. And the record will speak for itself about
Yes,
when?
ma'am.
Okay. Shifting gears a little bit, now it wasn't your strategy to discuss hydration in depth, was it?
Was it my
Dehydration and?
No.
Okay. Why didn't you focus on dehydration?
It seemed to me that dehydration, along with the corporal punishments, along with deprivation of food, along with all the other burdens that young man had to go through, were part and parcel of the same issue. Our argument was she did not form the intent to injure this child. So whether she injured him with dehydration, or she injured him by starving, or she injured him by thermal, it wasn't an issue. The issue is, did she intend, did she know, did she create the intention in her mind to hurt this boy? And that was the issue. So I didn't concentrate on the other issues that the coroner said went into causing his death either, because they just weren't the issue I wanted this jury to concentrate on.
All right, Carmen is leaving us.
I don't know how this sounds, so if it sounds really bad, sorry. I just wanted to show you my happy spot. And then, since we live 1,000 miles away, I was gonna show you the sunset. That's all I wanted.
Are you going fishing? Do you have a rotisserie chicken?
What?
You need a rotisserie chicken when you're near water. Don't you know anything by now? Good Lord.
Well, I was doing, I don't know if I can show you. I was doing this, calling in the gators.
I figured you picked your feet up because you thought a gator came.
Well, there was some bubbles over it.
I figured.
That's why I started laughing. Because there was some bubbles. I was like, uh-oh.
I don't need Carmen to show me that ever, Bobby.
Yeah, no.
That would be.
But no.
That would be weird.
That would be weird because she's my bestie. You weirdo.
She's my
I can't see the chat, so.
That's okay.
But no, this is my favorite place. That's what it looks like.
You meant Carmen. I was wondering how you knew what Gabby was doing, Robin. I was like, maybe she told you and I missed it.
No, one wants to see my happy place. Trust me. Not as bright and shiny as Carmen's.
You're glad to see Carmen relaxing. Got it. That makes sense. What's up, Katie? Good to see you. Hope you're having a great day. See, this is what it looks like. I got it, Bobby. All right, while we're paused real quick, Carmen, thank you for being a member for 23 months.
Wait, also
And
great pause. Look at him. Look at his face.
He's like, I got something to tell you.
He's like,
That's what I look like. That's what I look like when I accidentally pooed on the floor.
No, you didn't do that. You pooped. Also, Sticky, thank you for the 5 membership. Yeah, he's got a dizzy spell. Don't say that word again, Carmen. I hope I can read my own pencil writing. Amara's Gigi, Jimmy James 6. I like that name's fun to say.
Jimmy James. Jimmy James.
7809. Awesome mom of 2. Crazy Cat and Megan Denise 82 all got gifted memberships from Sticky. Thank you, Sticky. I am very appreciative. Congratulations on your win, and thank you for sharing. Alrighty.
You see that?
Your head's in the way. Oh, that big house?
They have a helicopter pad. I want to make friends with them.
Alright, well.
Why, Carmen, do you have a helicopter?
Yeah.
No.
He's pretending not to have teeth.
He's just gonna give your little toes a little nice little clean gummy real quick.
That's why she put him up on the dock.
Yeah. Just come by, suck a toe, and move on.
Gross.
Alrighty. Well, enjoy the rest of your evening.
Like I said, I just wanted to show you the sunset.
Well, I'm glad you didn't lose a toe to a actual gator.
No, I have to pee, so I'm gonna put my shoes back on.
Thank you for announcing your bathroom needs
You're
to
welcome.
this chat that already knows way too much about your bathroom.
Well, I figured since they already know this much, they might as well know the rest.
Well, alrighty then.
What would have been
You
more
guys have fun.
hilarious is if Carmen just jumped into the water and was like, "I gotta pee."
Hey, listen, if I didn't have pants on, that'd probably happen. 'Cause it's a little warm outside.
Yes, to be fair, I am the one that told you, but she would have told you sooner or later because she's already told the story.
I don't care.
I've heard that story before,
Yeah. So,
but in a
there
good
we go.
way.
Oh, I got the house wrong. Not that one. That one.
Okay. It looks like it looks like a big sand pile to me.
Yeah, it's like little Lego houses. All right, I got to get back to this because I
All right.
get
Bye.
finished. See ya.
Bye.
Okay, we're almost to a break. That was a good break anyway. He looks funnier on the big monitor over here. I've done it
Quick, you
twice.
Hear it? You hear the plane.
I hear it. Robin, I did this trial twice.
Yeah.
I did it when it was live, and then I did it again last year as we were getting ready to go into this, her
Yeah, but you
hearing
didn't
that
do the whole hearing, the whole trial, did you?
I did the whole trial.
Oh, okay.
Yep.
Maybe the second time for me was faster.
Probably was. But yeah, I'm going to cover the hearing.
When is the hearing?
Well, this part happened in November. The other part that we're going to watch Thursday happened last week. And then I will have to keep an eye out for his written ruling.
Okay.
And then you guys will get to hear me read it. And that'll be exciting.
Oh my god. Should we get Flashman in here to read it as if he were a female?
Yes.
It's going to be more epic now that none of us are sick to read something out loud. Because that would be really fun.
don't watch the original. That was
Yeah.
my only second live trial, and it was so bad.
Go to the
But
second
it's
one.
still like in my top all the time. So bad. All right. Here we go.
Okay.
Some trail mix is good as long as it doesn't have any dried apple pieces in it. Apples are weird. I don't eat them.
I mean, I like apples.
raw
I like
apples
cut
with like
yeah,
peanut butter
peanut
on
butter.
them.
Yeah, me too. But not apple pie. I mean, I make pies, but I don't like pie in general. It's a
We don't have that
texture
much.
thing.
We don't have that much more to go. Snipe, we're about to a break, and then there's about 34 minutes left of the judge questioning the attorney, and if we don't do that today, we'll do that on Thursday. So, but we're about 10 minutes until we get to fast forward to that 34 minutes. Could I answer that any more confusing?
I mean, there was a little deciphering, but still haven't got my brain
well,
yet. You know, I'll get there.
I try. Okay, here we go.
All right.
Okay. So that was a conscientious choice on your part.
Sure, and we weren't arguing that I was dehydrated. We weren't arguing that he passed away. That he was underfed. We weren't arguing any of that. We were arguing intention.
Do you think if you would have argued that he didn't have his water access restricted, that would have furthered your strategy at all? Or presented the case in a better light for you?
I think I would have lost the jury on that. They had photographs of this boy. And nobody's going to take a look at those pictures and say, this boy needs water.
Now, there's been a claim that you provided deficient performance for allowing commentary in lieu of a video. Are you aware of the video that I'm mentioning?
Yes. The
Okay.
best thing I did in that trial was the best thing that happened in that trial was the fact that video didn't come in. That video is literally the worst thing I've ever seen. There is no commentary that can express to a jury how bad that video is. The commentary was by leaps and bounds better for our client in showing that jury that video. I'm so pleased and grateful that the people did not push to admit it. That video is just awful. And to the day I died, that was the right strategy. It's the best thing we did during trial was keep that video out. It is just awful. You see it, you'll never forget it.
And just to go back a little bit and expand this, were there in-chambers discussions between yourself, Mr. Roberts from the prosecution, and the court about this specific video and the presentation of it to the jurors?
Yes, ma'am.
Okay, could you just sort of place on the record the summary of that in-chambers
My position was that the video was so prejudicial that nobody who saw it could unsee it and not give it and not absolutely close on it. It's just it was, and given the weight of all the other information that Mr. Roberts had presented, it was duplicative, and therefore we shouldn't allow it in. That was my argument. Ultimately, as I recall, Mr. Roberts just agreed not to use it. We use this description, but we wouldn't use the actual video.
But that was due to a strategic stipulation, correct?
Yeah, that was big. That was one of the best things we did.
And it wasn't an oversight that you just let hearsay in?
Oh, no, ma'am. That was a relief.
I can just have one moment. Okay. All right. Thank you, Mr. Johnson. I have no further questions.
Thank you.
All right, Mr. Ambrose. Any follow?
I swear this attorney is not paying attention. He's had to
You mentioned that
remind him twice what he's
the
doing.
morning of December 15th, 2023.
He might have
Ms.
taken
Vander
pot.
Ark was on the floor, curled up.
That's the day when she refused to, when she declined to come to court? That, you talking about, counsel?
Yes.
Yes, sir, that's how I found it.
And you did you used the word competent, but you stated that you were using it to the court as part of a, in layman's terms rather than a legal definition.
That's correct.
After the trial in this case, do you recall providing any interviews with the media?
I believe they were standing in the corridor,
Okay.
and I believe they did speak to me.
Do you recall telling, when asked a question about your conversations with, or your interactions with Ms. Vander Ark, that she was in a catatonic state?
I may have used that term, yes.
Okay. And so that's kind of a serious situation, right?
Yes, sir, it is.
And that's more or less what you reported to the court, is that correct?
Catatonic state is a more egregious, is a higher level of incapacity than I reported to the court, and it's what I report to the media.
Yeah, there was some testimony regarding dehydration, and it was your decision. Was it trial strategy that you did not use dehydration as a way to explain the death of Timothy?
Was it? Yes, sir. The trial, would you like me to, the answer to the question, the trial strategy was not to try to explain that there was food in the house. There was water made available. The other children had corporal punishments as well. The decision was not to try to explain that these were causes of death. The decision was to explain that my client never intended this outcome.
Was there, to your understanding, was there any restriction on water
For
Timothy?
no.
And when's the last time you saw the death certificate?
I would have seen it before trial. Better than the last time.
May I approach the witness?
To me.
This was, it looks like it was People's Exhibit number 45 introduced at trial. Is that what you recall as being the death certificate?
I don't have any personal recollection, but this is the death certificate of the victim in this matter.
Okay, and what's the first thing that's listed as
Okay.
being the cause of death?
Okay. What box is that in? Do you know?
36,
Okay.
near the bottom.
Okay, 36. Dehydration and extreme emaciation.
Okay, and dehydration would be lack of fluids, right?
Yes, as far as I know.
And like you said, there's no restriction on water in the household.
That's what my understanding was. I wasn't in the household, so I don't know if it was or not, but that was my understanding.
All right, I have nothing further.
Ms. Lucas, any questions?
If I could just ask a brief follow-up.
Yeah, go ahead.
So, Mr. Johnson, if you would focus on Dehydration, would that open avenues to the prosecution to enhance some of their arguments?
I would assume.
Such as the fact that he didn't have access to water when he was locked in the closet, correct?
I didn't want to get into that.
That he did have access to water in the ice baths, arguably.
That's what I was afraid he'd say.
And ultimately, and unfortunately, but by the defendant's actions, Timothy was so malnourished and unable to move that he could not get himself water. Would that be accurate?
I would assume that's the case. At the end, I'm sure that's what the case was.
So there's multiple arguments and pitfalls if you were to take that strategy, correct?
If I would have attempted to argue that whatever in here did not cause the death, I opened the door for Mr. Roberts to show that, okay, it did, and that this wasn't an issue. And I didn't want the jury to hear more of that. I want them to hear that my client just didn't get it. That was the message.
Thank you.
Any follow-up to that, Mr. Ambrose?
No, Your Honor.
Okay. Mr. Johnson,
Sir.
I have some, well, it's a noon hour.
They're going to take a break. So if you guys want to watch, with approximately 34 minutes, it's the judge basically asking him questions. If you want to get through that tonight, and then we can just do Shanda's testimony tomorrow and be done with that for now. But yeah, the video, I don't know which video he's talking about that he says is horrible of his own client, which spoke volumes to me. The video that we were able to hear during the trial but not see, because the judge was really good about not showing us anything anything that made Timothy look bad. He did not want, he just said like he'd basically been through enough and he wasn't going to do that. But we could hear the video, we could hear Shanda, we could hear what she was saying to him as he's dying. Like, she's dragging him down the hallway to the closet. It's so bad. She just has no... I cannot have sympathy for this woman. I just cannot. Because I just don't think she deserves it. All right, I can't see if I'm fast forwarding.
The parties
There we go.
concluded their questions. The court did have some questions for Mr.
100%.
Johnson. Mr. Johnson, you obviously know you're still on road.
I do.
All right. Let me just see here. There were some questions about by Mr. Ambrose regarding the suspension.
Yes, sir.
That I think occurred, last year or this year?
I served it last year. It took almost 9 months to get the process rolling, so it actually occurred the year before.
All right, and my understanding, and you've actually been here on a Ginther hearing for that case, correct?
For that case, yes, but not for that issue.
You're not for that issue, but in this court, correct?
Yes, sir.
In this very courtroom, correct?
That is correct.
Okay, and that was for it was People versus LTJ Udall, is that correct?
Yes, sir.
And that was 2019, I think it's 947 FC?
Yes, sir.
All right. And I just wanted, for the record, my understanding is the basis of the disciplinary action was that in that case, let me just go back. My understanding of the facts of that case, very briefly, Mr. Udall was charged with criminal sexual conduct, I think in the first degree, is that correct?
Yes.
Okay. And the victim of that charge was a client or represented by the public defender's office, is that correct?
Yes.
And that was in an abuse neglect case or an NA case, correct?
Yes.
All right. In my understanding, you did not actually handle that case, correct?
That is correct.
And was it other members of your office that had handled it?
Yes.
And my understanding is there was a file that was taken from your office detailing this minor child's counseling records, psychological records, is that correct?
Yes.
And my understanding is that you actually used those in Mr. Udall's defense.
I saw them, they weren't used.
They weren't used, but you certainly used them to prepare.
Yeah, yes, sir, I read them and I knew.
And my understanding is there was supposed to be, you were supposed to isolate yourself from that. That was you was set up to isolate yourself from those files because you knew there could be a potential conflict. Is that correct?
Yes, sir, we had processes in place to make sure that didn't happen.
Okay, and that did not happen.
That's correct, processes failed.
And so essentially you actually used what were supposed to be withheld from you.
Yes.
In that case, Mr. Udell's case. Is that
Yes,
correct?
sir.
And that was the basis for the judiciary, or the complaint,
Yes,
the
sir.
grievance, correct?
Yes, sir, it was.
And you admitted that this happened, and I don't think you contested it at all, correct?
That is correct.
All right. And that's the basis for the disciplinary action, as far as you know.
Yes, sir.
All right. As far as you know, did the disciplinary action have anything to do with, not getting back to your client or not talking to her, doing something that you weren't supposed to do in terms of representing, something similar to what's being alleged in this case?
No, sir.
All right. My understanding is that there was Mr. Udell's case, actually 2 trials, is that correct?
Yes, sir.
All right. And you represented Mr. Udell in the first trial, is that correct?
Yes.
And that what was the result of that trial?
That was a hung jury, Judge.
Okay. And then the second trial, I have, at least according to what the records say, is they occurred in December 13th to December 15th of 2023. Is that your recollection?
Yes, sir.
Okay. Now, you had testified, Mr. Ambrose had asked you about, your stress level at that time. You were on a conveyor belt. Was that true at the time of the second trial in Mr. Udell's case? That you were on a conveyor belt? I think that's one of the reasons you said what was going on for the disciplinary action. Is that true?
Judge, it was.
Okay.
That the workload continued unabated for the time I was at the public defender's office. It was self-inflicted. I didn't go on vacations. I didn't, when I retired, I had 50 more days of vacation time that they didn't even compensate me for. I was at that office and I was doing that work. So yes, it was a continuation of the same process throughout the entire time. The only difference being was when it came to a capital, well, it's not capital in Michigan, but a life case in Michigan, the priority shifted so that the abundance, the time that I needed for that case would shift to that big case, the life case, as opposed to misdemeanor cases that I might be working on.
And I actually misspoke. So my understanding, I got this trial, Ms. Vander Ark's case actually took place between December 13th and December 15th of 2023. Is that your understanding?
Yes, sir.
I had it wrong. That Udell case happened in April of 2022. Is that
Okay.
your recollection?
I thought so. I thought his was done by the time Ms. Vander Ark began.
Okay. So this trial, did you go right from the Udell case to focusing on Ms. Vander Ark's case? Because
No.
it looks like they went from April 2022 and then a little over a year later, you're trying another FC case.
No, I think there were at least a few weeks in between. I don't think so.
All right. Now, was there, looking back on it,
Yes, sir.
were you able to give Ms. Vander Ark's case what you felt was the appropriate amount of attention for an FC case?
Yes, sir.
Okay. Was that with the assistance of the people you've already indicated?
Yes, the team did.
Wasn't all you, it was the team?
That's correct.
All right. And would you say that you were in charge of the team? Like,
Yes, sir.
you weren't absent and said, look, you guys do all the work, I got to take care of everything else? Or were you there for meetings? Were you there for other stuff?
I was there.
Okay, all right. And I'm trying to understand the defense strategy, okay?
Yes, sir.
From what you've testified to, my understanding is that your strategy was to essentially go from a intentional crime to a negligent crime. Is that correct?
In effect, yes, a crime where there wasn't the mens rea to commit harm. So yes, sir.
At the break, I looked at the jury instructions, and it looks like you, correct me if I'm wrong, I can't remember exactly, but did you ask for the involuntary manslaughter instruction?
We did not.
You did not?
No, sir.
Okay. But it was included, correct?
Yes, sir.
All right. Was that at the request of the prosecution, do you recall?
Now that you mention it, I don't remember who asked for it. Now that you mention it, I don't know, because we, obviously, for the record, we discuss these instructions in chambers, and the instruction, it would have come up, I don't know who asked for it. It might have been me, I don't remember.
Okay. So my question is this. You had testified at the beginning of Mr. Ambrose's questioning that Ms. Vander Ark had not given you consent to ask the jury for a manslaughter verdict.
That's correct.
Was that your testimony?
Yes, sir.
But then later on you said focus was going to be, this is not an intentional crime, that there's just something wrong with it, correct?
Yes, sir.
My question to you is, when these discussions between you and Ms. Vander Ark, did she unequivocally say, I am not guilty of any crime? Or was the discussions, look, I didn't do this intentionally, I didn't mean to do this, I'm not going to plead to something that I didn't intentionally do? Was there a dichotomy in that discussion?
The discussions about her responsibility came in two phases. The first phase, when we first met, she told me the same thing she told the police at the time that the boy was discovered, that she found him in the bunk bed, she poured him down, and she's trying to administer CPR, and et cetera, et cetera. That's the first thing she told me. Then after that, once we got past that and the police reports came in, it was clear that wasn't the situation. We talked about individual defenses to individual crimes. And we covered everything. We covered all the things that she might be, that her conduct might find, the jury might find her guilty of. I never directly challenged her, did you do something here? And that's not my way. The client either wants to talk to you about that way or they don't want to. But based on the conduct of our conversations, it was clear that she was aware that there's something that's wrong here. There's something that I may be found guilty of. And that's kind of how we kind of, in order to bridge the gap from her having to confess to me, we kind of discussed it as there's something you might be found guilty of, and this is the things you might be found guilty of, and this is the things that we might be able to achieve if we do these sorts of things. And avoiding, and the bottom line is avoid first-degree murder.
Okay. So it was never, she never said, well, I'm guilty of something. It was more of discussion about, okay, throw it all. What could the jury eventually find? What's a mitigating thing we can do? Is that right? That
was the strategy, Judge. It was never, I never confronted her to ask her if she did something wrong or not. I gave her the way out. The jury might find you guilty of these things. What are we talking about? And that's how we bridge that gap.
All right. So there was never an affirmation on her part that I recognize that I am guilty of a not unintentional type of charge.
Never before or since.
Okay. And it sounds like initially you wanted to find an expert witness to assist you in that defense, correct?
Very much so.
And you went through, you tried 2 different expert witnesses, is that correct?
We hired 2 different ones. We talked to 3 or 4 others, and we talked to other people, but we hired 2.
Right. And is it your testimony you could not find an expert that could assist you in that defense?
Yes, sir. That is my testimony.
Did you discuss with Ms. Vander Ark that you were going to make the argument to the jury that she was guilty of an unintentional, negligent type version of either manslaughter or homicide? Did you ever discuss that with her, that was the strategy?
I can tell you how we discussed it. First-degree murder is an intentional homicide. You didn't intend to do anything. And that's the argument we're going to make to the jury. That's how we discussed it.
Did she ever say, wait a minute, no, I don't want you to do that because I'm not guilty of anything?
No, Ms. Vander Ark, again, she was the client from heaven. She sat and she listened and we talked. She understood, and then she trusted my judgment. At least her conduct indicated she trusted my judgment from that second week on. The The only thing, Judge, the only thing we ever had a crossword on was about the Michigan-Alabama football game.
So again, she never said, Mr. Johnson, that is not an argument I want to make. I am maintaining my innocence to every single thing, that I am innocent, and I absolutely do not want you to concede any sort of guilt in any way, shape, or form.
That is absolutely correct.
Okay, that she did not.
She did not ever.
And you feel, coming from defense background,
Mm-hmm.
sometimes defense attorneys have a tendency to kind of, they think they know more, they know what's better for the client, right?
Yes, sir.
I know you don't want to do this, but we're going to do it anyway because I want to make sure that we're successful here.
Yes, sir.
Did you do something that she did not want you to do to be successful, or did you do what you had to do in consultation with her about what the strategy was going to be?
The latter. And again, this is a different client than what we normally receive. This is a client who's much more sophisticated about the law and had much better understanding. And our relationship was more co-counsel, or maybe senior counsel myself and junior counsel, but more co-counsel than lawyer layman or layperson. She understood the strategy. She conceded that was the strategy that we were going to use at trial. She understood it. She knew I was going to do that. Did she know the exact wording or how it would come out? No, she didn't, because I didn't. But she understood it, and she understood what we were going with, and at no time did she express concerns that I don't want to do it that way. I want to go on and say, I didn't do anything. I wasn't even, whatever her argument would have been. But no, I never asked her if she committed the offense. She never told me she didn't commit the offense.
The other question I have is, in all these discussions, I mean, obviously you're saying not first degree, not premeditated.
Yes, sir.
Not second degree, not, because that's an intentional crime,
Yes.
right? Not necessarily voluntary manslaughter,
Yes.
but was there ever discussion, well, listen, this is the charge, we think, let me back this up.
Okay.
You had said, you argued to the jury with manslaughter because you were hoping that they would find a middle ground and go for second.
Yeah. Yes.
Was that the strategy that you guys came up with? Or was that kind of like in your mind, you said, well, wait a minute, worst case scenario, maybe it would be second, but I really want manslaughter?
Okay. No, this is a strategy that I came up with. We did not come up with it. This is the strategy that I suggested to her, that I told her that I was going to follow. And at no point did she express to me that, no, I don't want to do it that way.
When that final day when it was the last day of trial,
Yes, sir.
you indicated she was in a ball in the holding cell. Did you ever suggest doing Zoom, potentially? Her zooming in from outside the courtroom for the trial?
No, I did not.
Okay. Did you feel rushed at all that morning by either myself or the court or anybody else to kind of say, let's get this rolling? And
Not rushed. I wish we'd have adjourned it for another day and see if she could come around. But no, I didn't feel rushed. I understood that the issues were presented to the court. The court made this call. It wasn't that that the court was trying to rush me to do something. It's just that this is what the court thinks we're going to do, and so that's what we do. I didn't feel rushed. I just okay.
it was I think we waited a couple hours, correct?
We would, yes, sir.
All right. And now I want to make sure. I mean, you're obviously aware of the legal definition of competency in terms of the state of Michigan.
Yes, sir.
Can she rationally assist in her defense? Does she understand your job, the prosecutor's job, the court's job, the jury's job? Do you feel that she was legally, according to the standard of the state of Michigan,
Okay.
would you believe that she was legally competent in everything that you observed that day?
Yes, sir.
Did she ever ask, say, hey, listen, I want you to ask these certain questions?
No, sir. She directed me to ask very few questions. She had observations, but she didn't.
I'm talking about that day.
Oh, that
She
day.
was in that
No.
state. Okay.
No, sir.
I think her affidavit says she had a lot of questions that she wanted to ask the witness. I think what part of that, I'm paraphrasing.
Mhm.
I'm just wondering if those were ever communicated to you when she was in that state.
No, sir.
Any follow-up, Mr. Ambrose?
Yes.
Yep, go ahead.
It was your request, the lesser included, is that correct?
Probably.
Okay.
It was a chambers discussion when we talked about the instructions, and so I don't have any specific recollection, but probably I can't think by the people would want that instruction.
Okay, may I approach?
You may.
All right. And this is a transcript of December 15th, 2023. Page 41 near the bottom and going to the next page.
Okay.
Does that refresh your recollection that it was your desire, your request for the involuntary manslaughter instruction?
Be honest, counsel, I still don't remember asking for it, but I don't have any reason to dispute what's written there in the transcript.
And it does say that
That I-
Mr. Chambers, or Mr. Johnson is your, so my understanding from our discussion in Chambers, Mr. Johnson, is you're requesting an instruction on lesser included offense of involuntary manslaughter. Is that correct? And your response was, that is correct, Judge.
Okay,
Right?
Yes,
You
sir.
agree with that? So it was your request.
clearly.
And so my client's, Ms. Vander Ark is not in the courtroom at this time, correct? December, that's that Friday.
If that same day?
Yes.
No, she's not in the courtroom.
And you're not discussing involuntary manslaughter with her when she's balled up on the floor, right?
That's correct.
And she's catatonic, right? Is what you said.
It's what I said to the press, sir.
Okay.
She was distraught, and she was literally curled up in a ball and crying on the floor.
And you're not discussing with her at that time, or are you? Hey, I think I can go with the involuntary manslaughter. What do you think?
Correct.
All right, and throughout, from day one, Ms. Vander Ark said that she was not guilty of this offense. She maintained her innocence, is that correct?
As I've said, I never asked her if she did it, and I don't recall her saying, I didn't do this. There's quite literally videotape of her conduct. So I don't recall her ever saying, I didn't do anything. What I recall is she never told me that she intentionally did anything to her child, or to any of her children. And that's what I recall. I don't recall her saying, I'm not guilty, this is not me, I didn't starve my child, that sort of thing.
Did you guys ever have a discussion? Ms. Vander Ark, you kind of meet these elements of involuntary manslaughter. You want me to see what I can do with the prosecutor, see if they'll accept a plea?
Sort of. What we talked about was she's charged with this homicide, and these are the possible outcomes a jury could legally come to, and these are what they require, and it may be and we talked about it. If we're winning the trial, what do we do? If the trial's not going sideways, what do we do? That sort of thing. But she understood that there are options, and that and during our conversations, my conversations with her, that we talked about what we might argue on if the facts support it. Does that make sense?
Well, you mentioned on direct in the morning, it was kind of your decision to,
Yes.
to argue to the jury that she's guilty of involuntary manslaughter.
That's correct.
My client, Ms. Vander Ark, never said, I'm guilty of voluntary manslaughter.
That's correct.
And just as a general question, on December 15th, when she was, on the floor and in distress, did you request any type of medical assistance or have her evaluated?
No, sir.
Your Honor, I don't have any I don't have any further questions.
Just a couple briefly, and Your Honor, I guess I would just ask the court at this point in time to take judicial notice of the opinion and order regarding new trial in the LTJ Udell case. I do have extra copies. I wasn't anticipating admitting it, but given the court's questions, I think it's just come up. There's been a Ginther hearing. This is the court's ultimate opinion on the matter. So I just asked the court to take judicial notice. And I do have a copy for admission if the court wants it that way versus in the
Yeah, that's fine. I think I can take judicial notice of it, right? That's what you're asking, because
That's what I'm asking.
it's in the file, so.
And I would just mark it as People's 2, proposed 2.
All right, Mr. Ambrose? Any objection?
No.
Okay. Do we have exhibit 1 too, by the way? Is it still on this?
It is.
Does it need to go anymore, or I'm just going to make sure I keep track of the exhibits? All right, good enough.
Okay. Mr. Johnson, is it, I'm sorry, Your Honor, may I proceed?
Oh, okay, so this is the opinion order in LTJ Udell case, correct?
Correct.
Okay, all right, I wasn't, Mr. Ambrose, were you aware of that?
Yeah, I mean,
I wanted to make sure we're on the same page.
Yeah.
Okay, yeah, I remember it. Go ahead.
And just to confirm, it's been admitted?
It is. Yes.
Mr. Johnson, is it fair to say that you're aware that involuntary manslaughter is a necessary lesser included offense to murder?
Yes, ma'am.
Okay. So if the record shows that you requested it, would that be standard course and an open murder charge to ask for that?
Most certainly.
And you did in fact go over involuntary manslaughter and what that would entail with your client?
On multiple occasions.
Okay. And so it's not that she's in the jail, she's away from you, and you just decide to ask for the instruction right then and there without consulting her?
Well, I didn't ask her if we could put in the instructions, but we talked about that argument being an option.
Okay. Did she condone that option?
She doesn't do that. She doesn't say, okay, you got it, I will do it that way. She simply, I tell her this is what I think we should do, and she nods and yes, and okay, and that sort of thing. She's not the kind of person who was going to challenge, I think. She understands and she trusts.
Okay. Did you feel that she was aware about the strategy about attacking the mens rea elements?
Yes, ma'am.
And based on your knowledge, mens rea is different for first degree, second degree, and manslaughter, correct?
Based on my knowledge, yes.
So while you might not have used the words manslaughter, was she aware that there was going to be some concession of mens rea in some way?
Okay.
Maybe negligence or something along those lines?
We discussed options prior to trial, and I told her what the options were, and that as depending how the evidence came in, we would select one of the options. One of the options I told her that I would be selecting would be this negligent homicide argument. So did we sit at the table and talk about it during the trial? We did not. But she was aware that was an option, and she was aware that I was considering it, and she never objected to it.
Thank you.
Mr. Ambrose?
Did Miss Vander Ark ever express to you her guilt of anything?
No.
And her testimony at trial, would you agree was an expression of her being not guilty?
Yes.
Of her belief
Yes.
that she was not guilty of anything?
Yes.
I don't have any further questions.
No, thank you.
All right. Mr. Johnson, I just want to clarify, I think we're all dancing around the same question here. Did you ever say, hey, listen, I'm gonna, to her, in those words, we're gonna go for involuntary manslaughter?
No,
When you said possible outcomes, did you mean, hey, listen, open murder, you can be first, second, voluntary, involuntary? Is that what you discussed with her?
that's what we discussed.
Okay, and did you discuss all the elements of all those?
Yes, we did.
Okay, and it sounds like you discussed 1 and 2 are off the board, correct? I mean, that was not something you guys were gonna argue, correct? First and second degree?
Most certainly not.
Okay, and when you guys talked about, so my understanding is as the trial progressed,
Mhm.
you were waiting to see how the proofs came in, to see exactly what manslaughter was going to be argued or just completed. And I mean, did you ever foreclose the idea of the argument to the jury that completely not guilty of everything?
No, sir, that's the first argument.
Okay. And then was it, okay, listen, depending on how things go, then we might have to say, all right, well, that's out the window. Maybe we should argue involuntary manslaughter.
Yes.
All right. When you guys discussed this, did you use those terms, involuntary manslaughter?
Yes, by name.
Okay, so you actually said involuntary manslaughter to her,
Yes,
and you believe she understood that?
yes, both manslaughter by name. She's a lawyer. She understood, so I wasn't as reticent about not, but by breaking it down as I normally would be. She understood all 4 the options, and we talked to them by name.
Okay. When did it become apparent to you in the course of the trial that the complete innocent verdict was gone? That the fact that you were going to go for not guilty completely? That you said strategy number 1. When did that occur to you that it went out the window?
Judge, if you'll recall, there was a point in the trial where the witness testified that he sent my client a photograph on his phone of Timothy, and he was shirtless, and the pants were falling off of him, and he sent this photograph to my client, and my client saw it and responded to it. At that point, given that the jury, at that point, it became clear to me to tell this jury that there is no guilt here, was not going to be an effective argument for this client.
Was that discussed with Ms. Vander Ark?
Specifically, no, not that specific.
After that day, did you say, hey, listen, option 1's off the board, we're going to have to go with option 2?
No, sir.
At any point in time, was it discussed?
No,
After that?
No, I did not. I would assume that had she been here, we may have, but that's just an assumption. I don't know. But certainly, the realization, the decisions that were being made during trial, whether or not she was going to testify or not, that was done at the point when it became obvious that it might help her. But matter of fact, that's the other decision that was made when that picture came in, that she's going to have to testify. But no, there wasn't a sit-down discussion saying, hey, we're going to go for an involuntary manslaughter here. That did not happen.
Were there previous discussions that at some point that could happen, that you would have to be, if 1 was off the board, you have to move on to option 2?
You mean?
With Ms. Vander Ark?
Yes, that was discussed. Yes, that was discussed along with, and I reviewed the file, I knew it was in it, along with the likelihood that not guilty was not likely here, that we would probably be doing something to make sure you don't spend the rest of your life in prison.
When the option of involuntary manslaughter came up in all these discussions,
Mm-hmm.
was it ever expressed by Ms. Vander Ark? Absolutely not. I'm innocent.
No.
All right. Sorry to open the door again. Mr. Ambrose, any other questions?
Yes, I mean, okay, so during the whole trial,
Mm-hmm.
you hear all the prosecution's case, right?
Yes, sir.
And in the trial, you make a decision or you discuss with Ms. Vander Ark that it's probably in her best interest to testify, right?
Yes, sir.
And that occurs when this photograph shows up or appears. That was a reason to have her testify, or is that?
Yeah, there was as you know, with trials, the information accumulates, and when that piece came in, that.
Now, during your questioning of Ms. Vander Ark,
Mm-hmm.
do you ever ask her, Ms. Vander Ark, it sounds to me like you committed some sort of crime.
Did I say that? No.
Yeah. And you never asked her on direct examination, well, don't you think they have a case here for involuntary manslaughter? Do you ever ask her anything like that during the trial?
No.
And I think on direct examination, you kind of said that it was your argument to make to the jury that she was guilty of involuntary manslaughter.
Yes.
And yeah, I have nothing further.
Just very briefly.
Mm-hmm.
She wasn't convicted of manslaughter, was she?
No.
So the jury rejected your concession anyway.
Yes.
So there's no, never mind. I have no further questions.
Any call for that, Mr. Ambrose?
I'm through.
All right, good enough. May this witness stand down, Mr. Ambrose. May he be excused.
Yes, thank you, Mr. Johnson.
Yes, thank
All
you.
right, thank you, Mr. Johnson.
Thank you.
You are excused.
Oh my gosh, why? Absolutely. What in the world? Did you ask her if she thought she was guilty of involuntary manslaughter when she was on the stand? No. My gosh. That was
Hey,
bad.
do you like chocolate cake? Never mind. I don't even want to know. Never mind. Forget I asked that question. Never mind.
Oh my gosh. All right. Well, I have nothing else, yeah, because I had nothing to begin with, but I'm here to do my job. Just like that poor guy on the stand.
I honestly think that he did probably the best that he could do. And for them to ask him those types of questions, like he said, she was a lawyer. She understood the terminology of all of these things. He told her his course of plan, and like he said, she didn't object. She knew what they meant. We all know how smart she really is. So
she told us,
don't
yes.
let this fool you, people. She knew what was going on.
Yep. And her illnesses only come on when she, one, has to go to court, or two, she gets stuck in a situation she can't get out of, such as him putting the horrible photographs of her now deceased son on the stand in front of her. He just laid them out there. And she was like, oh, I'm throwing up. No, you're not. No, you're not.
I'm sorry. Excuse me. I had bronchitis and I was on an inhaler. You know what my mom said? I don't give a crap. Get up. You're going to school. So, F your headache, lady.
Yeah. Yeah, I mean, he said, I made sure to not ask her if she did this. I didn't ask. She didn't tell me. So why would I ask her if she thought she was guilty of manslaughter?
And not just that, but he did say there's text message proof and video proof. He didn't need
And they're
to
bad.
He didn't need to ask. Anybody can go and see and read and watch this happen. She had cameras all over her house. Everybody can see it. So he didn't even need to ask if she was guilty. He knew she was guilty. He was just trying to get her, like he said, not spend her life in prison.
Yep. I mean, yeah, he was trying to get number 2, murder 2, whatever. I was trying to be nice, and then I decided not to be. And she's not. You got convicted of the thing you should have been convicted of. They got it right. The judge got it right. Your attorney did the best job he could do with what you did. And then he tried to get you a lesser charge, and you are so ungrateful.
And then she asks for this. She asks for this hearing to get a second trial, and she's just wasting the judge's time this whole time. I have a headache. Oh, can we push it? Oh, can we No, lady, you're not in charge anymore. Exactly, Robin. I will preach about this lady all day. I cannot stand this woman. Oh, she's the worst.
That's what I said. I warned you guys last night. This is a polished turd. That's how we got into the whole Carmen situation. But it's still just that. It's you start with a turd and it's still just a polished turd at the end of the day. But he did his job.
Yeah,
He did his
I
job.
believe he did. I
He
believe
had
did.
nothing to work with. And remember that day she was chewing gum
Oh,
in
yeah.
court? Oh my gosh.
Once I saw that, I was like, AJ, don't look. Don't look, AJ. Don't look. She's chewing gum in court.
It's chewing gum court. You know better. You work in court. That just tells you, to me, how just above all the rules that she just thought she was. I can't stand it.
It's
I
AJ's
can't.
pet peeve.
You don't do that. It's most judges will be like, spit it out. And that judge was. He said, "Is your client chewing gum?" Yep, spit it out. And he should have went on further to say she should know better. Oh, judge saw right through her. And it was amazing. It was amazing.
This case and Adam Montgomery's case, this case and Adam Montgomery's case gets me so heated every time I think about them. Like, it's so mad.
Well, he's another one that he didn't come to the whole entire trial. Refused to come. And it's like,
Yep.
you're a horrible human. The judge made him come on a sentencing or verdict. Did he have to be there on verdict day?
He had to
Or just
be there
sentencing?
on sentencing. He was there on sentencing. I know that.
But, I mean, it's just... What were they going to do? Put her in jail? Nope. They were going to put her in prison. For the rest of her life. Bye.
I hope they
That's what
slammed the bars right in front of her face, too. But I bet you
The
that's
judge-
what gave her a headache. The slamming of the bars. From the first day she walked in there, she just had a constant ringing in her head.
The judge... Shut up. Shut up, Bobby.
I knew he was going to say something about that. Once you said it, I was
Me
like,
too.
AJ,
I knew it.
careful.
I knew one of them. I know bad's still lurking around.
He's like, wait, did someone say come?
You just did. And now no. No. Don't. Like, it's, yeah. I don't understand.
How about the one with Judge Simpson in her robe? She's like doing her makeup while she's in court, talking to him. Remember that? That was hilarious. He's like, "Excuse me, what are you even doing right now?" He's like, I love. He like put his hand on his head, and he was just like looking at her sideways, like, "Is this woman for real?" She's in her robe.
Yeah, people are just, I don't get it. I don't get it. But,
See?
oh well,
He goes,
it's
"Hello."
not for me to get.
Bad answer.
That's why I suddenly said, hello. Oh my gosh. All right, so we will watch. There's a couple of, Shanda comes back to the stand for like a minute, and then she's she's ill, okay? Headache. So she does not testify. She steps down. The judge agrees, okay, fine. But then the state's like, hey, I've got my witnesses here, so I want to call them. And she called like 2 deputies. It was just about them being in the holding cell with her. There really isn't anything there. The one thing that I was hoping she would do, just because I wanted to hear I wanted to hear his thoughts on this trial, was call the prosecutor. He was on her list. She does not end up calling him. I was like, darn it. It was not the sheriff. It was just the deputies. So we will spring forward and then back in time on Thursday and watch the most current testimony in this hearing that has gone on for 6 months now.
Did they recall her other son?
No. We will only hear from Shanda, whatever. And it's good. The prosecutor is the
Oh,
same
she's going to
woman.
get back up on the stand?
Yeah.
Oh, oh,
And
lady.
and it's good. So her cross-examination from the state is really good. Just as good as it was
Mm,
the first time.
mm. This woman
So,
is,
yes,
I just,
Ginger.
mm, she's
Oh,
terrible.
yes. Oh,
Oh,
sweet
sweet
baby
baby
Jesus.
Jesus.
Oh, yes.
Yeah, and let me tell you, sweet baby Jesus had nothing to do with this, but yeah,
Wait for it. Exactly. Exactly.
it's gonna be a nail
Ah,
biter.
what is that word? Coprolites is worth a lot of money, but it's just the same old crap.
Exactly.
Oh, bad Dazzer. You always make me laugh. Yes, when even Jesus face palms. Exactly. He was like, oh, why did I create her? Oopsies.
He forgives you, but still,
Yes.
it's like, dang girl,
So,
hell.
so, whoever, I don't remember the question you said. I thought I would remember and I don't. But this is one of those child abuse cases that we've watched, like, that we have seen where other children in the home are all left alone.
Mm-hmm.
And she had a younger son with her husband who had passed away. And when he passed away, that seemed to amp up this abuse against Timothy. So she did have custody of that son that she had had with her husband. She calls him Little Man in the hearing that we're going to watch on Thursday. He was fine.
They call
He
him
got to
G.
go. They
They have
called him
like,
G in this trial, yeah, and then she calls him Little Man in the
well,
next hearing.
technically, her husband wasn't dead at the time. He had had a stroke and couldn't get up the stairs, so he was living away from the house at the time because he was wheelchair bound because he
Yes.
had a stroke, so he couldn't get up and down the stairs. So he had to live in a, you know, handicap accessible home. So that's why he wasn't there.
Yeah. So, but it seemed like everything, because remember he was in the house for a little while
He was,
because
yeah,
he went up. It was like, you're making him go up and down the stairs? What are you doing?
yeah,
Like,
yeah.
he has to crawl.
Well, I
So,
guess it's never too
why?
late to want to learn how to army crawl. You know, I mean,
I mean, come
my,
on.
that's my only thing I can say about that. But
Yes, Ronnie, I think he was sentenced to 30 or 40 years. He got a long time. He really thought he was walking out that day.
oh yeah,
His
yeah.
sentencing
His
was so good, but
his
the audio
bottom
in it is so bad.
his bottom jaw, his head went up so fast. His bottom jaw dropped all the way to his kneecaps. He was like, "I'm sorry, what?" It was priceless.
Yeah. I mean, it was because he's playing this like, oh, poor me, poor pitiful me, like, oh man, judge, look at
She
me.
made me.
And then
She made me.
yeah, she made me. And then he was like, here's your sentence. And he's, what?
Yeah,
And it's like, bye.
talk about that song. Back to life, back
Yeah.
to reality.
It's like, see you never. See you
Yeah,
never. You're just
and then
young
those
enough
phone
that it's
calls
not
too.
life. Oh,
Those phone
man.
calls after. I'm like, yo, this kid is legit oblivious to the
He's
world. Like he has
oblivious.
no care in the world about anything but himself, just like his
I
mother.
had heard he had a fiance. I'm like, why? Stop, women. Stop.
Yeah, yeah.
Stop. You want to have a child with this thing?
Yeah.
He took
His
out his own
fiance,
brother.
his fiance is only in his dreams, and it's one of the lunch ladies who works at the prison.
I don't know about that. He was a bully. There was people he
Yeah.
there were people saying a lot of bad things about him and how he was not nice and he was a bully to Timothy from the get-go. And I mean, he had a job. He worked outside of the home. Did he work at Applebee's?
He worked at a restaurant like that, yes. Because I
He
remember
worked
them
at
specifically talking about that, how, because the lawyer had said to him, well, you could have brought him home food.
could have brought him food
Because
home. And
every
he
night when you worked,
didn't.
and you didn't. His mother
He
wasn't
did.
even home. He could have brought him home food. He
Yep.
could have given him food. You know what I mean?
Yep.
He could have done a lot of things to prevent a lot of things, but he didn't. He didn't try and stop it. He didn't try to tell his mother through the text messages while she wasn't even there. He's the
Yep.
one who did everything, and she was at work instructing him on what to do.
What to do at the
And he's-
courthouse.
Yes,
She was
while
at work
she's-
at the
Wow.
courthouse.
While she's court reporting in the courtroom, she's like, give him an ice bath. Did
Yeah.
he move? Give him hot sauce. Who are you, woman? I wonder if you look back in her court reporting, if it just randomly says hot sauce by accident, in the. I just can't. I can't even.
Around
it
6
makes me
years.
So mad.
Around 5 or 6 years, whoever.
So mad.
Yeah, they're bad. So bad. I could never confirm it, so I have no idea, and I don't really care. Allegedly, there may have been a really weird, inappropriate relationship between Paul and his mom. I have no clue. I don't care. I don't want to know. That was just things I heard through the YouTube grapevine. But I didn't try to verify it because gross. You don't want to know that.
I mean, he did get half on Applebee's app, so it's a deal breaker, AJ.
She was pulling up on her phone. She was watching all the time. She had cameras everywhere.
She could see everything.
He was always supposed to be basically being watched.
Or chained up. Or locked
Ew.
away somewhere.
Her several personalities might have kept things separate. Ew.
I mean, you never know.
And I totally thought that was him, Haley. I did. When he testified, I felt horrible for him. I'm like, he won't even look at her. I was like, this is horrible. He had to do this because, she was gonna do it to him, blah, blah, blah. I don't think that's the case. I don't believe that is true. That's just my opinion. Yeah. It's almost... Him passing away was the best thing for him because he was never going to get out of that house. They would have never allowed it. And he would have just been tortured because nobody knew he was there. He didn't go to school.
Yeah. They didn't even get she wouldn't even bring him to the doctor because one, she wasn't legally allowed to be around him.
Yep. So she couldn't get his medication.
She couldn't
She had
get
so many
any
excuses of
information.
everything she couldn't do, but she worked in a place she could have gotten help.
There's so
Had so
many
many people
resources.
she could ask. Just ask a lawyer, ask a judge, ask somebody.
Not
You're
just that,
around
but
all of them.
if she was afraid of getting into trouble, she could have just dropped him off at a walk-in clinic and stayed around the corner. And had his brother bring him in.
Yeah.
You know, there's so many different things she could have done, but she didn't.
Yeah. His brother, Timothy was 15. But Paul was 20 or 21 at the end of when everything happened. But so if you think about it, Shanda said he weighed 104 pounds in May after Mother's Day. And he was gone at 69 pounds. I think July 22nd.
Yeah.
A couple months. So there's no way. I don't know. She's like, I lose weight really fast. Okay, good for you. She was more concerned about her dogs than she was her kids. She had a YouTube page. She had a YouTube channel about her dog training.
Oh my god.
It's probably still up. I don't know. I tried to watch it one day and I wanted to punch my computer. So I was done.
Every time I see her
was done.
face, I'm just like, you did.
Yeah, he could have left. He chose not to.
Yeah, exactly.
I don't
mean,
know. I don't know. She wasn't supposed to have him. She was not supposed to have custody of Timothy. He was not supposed to be there. That so and it's really hard to find like any records on what happened because all that stuff happened in Oklahoma. So she leaves Oklahoma and comes to Michigan, but leaves all the kids there. I don't know how Paul ends up here in Michigan. And then supposedly the dad calls and says, I can't handle him. And here he is. So, but you just can't find stuff about it. I looked for a long time and I gave up just because.
Again, though, what you
Yeah.
said. She worked in a courthouse. She could have went right to her work, talked to a judge or somebody saying, hey, I'm not supposed to be around my son, but his dad just basically was like, I can't handle this anymore, and just dropped him off. What do I do?
Yeah. But
There
she did
would have
nothing.
been tons of people giving her options, resources. Come on.
Helping
I
her.
mean, this is
Just-
absolutely ridiculous. This did not need
Or-
to happen.
My husband is ill. Like, I'm the only person making any, that has a job that's bringing in any money into the house. Like, we're hurting financially. There's just so many things that she could have done that she just chose to not do.
And that's what makes you think, if you go back and watch that whole bit of him, of what's his name, Paul, reading the text messages back and forth between him and his mom, you can tell she enjoys it. She's enjoying what she's telling him to do, and then watching it on the camera on her phone at work while she's in the courthouse. Sick. She's sick. I'm sorry, but that is sick.
Yep. And I will tell you this. I hope she lives a long, long life.
Me too.
I hope it's a long
I hope
one.
they give her really, really tight cornrows in jail. Really tight. Like, I mean tight.
I really hope that she lives to be 120 in that jail, healthy, so they don't have any reason to let her go. Because, sometimes they'll be like, well, you're really sick and we don't pay for your care, so bye now. But no, stay healthy, my friend. Stay healthy. I'm just like, ugh. She won't think about it, but I hope she has a photographic memory so she can't unsee what she did. Yeah.
Because there's
In
no
fact, she
way in
wasn't
my
supposed
mind that when she saw that picture of Timothy, that she didn't know what he looked like. She knew
she
what
knew.
he looked like.
She knew. Because he had just shown her a picture of what you could kind of see it through the screen through the page of Timothy when Paul's like, I think we should actually feed him.
Yeah.
She could see that then. She knew what was coming.
She knew. She didn't care.
I don't think she did.
Heartless.
I think he was just a problem. And she wanted rid of it.
Well, I'll tell you one thing. Thank goodness. I don't know where G is now, but good thing he's away from her.
Absolutely. Absolutely. And I hope he's with stable people.
Yep. I hope he's young enough to not physically and mentally remember
just
what, because he saw stuff. I mean, he lived.
Yeah, even though
down there
she
with
said,
them,
even though she said, oh no, we made sure he never saw him. Like, we kept him away from Timothy because Timothy was such trouble. Whatever. Yeah, she did not care.
I mean,
Yeah,
I'm sorry.
so,
I would be trouble too if you locked me in a closet for friggin' 87 million months and basically fed me hot sauce. I mean, the kid, the poor kid, he's unmedicated and he has autism and he has all these things, and it's just not the way to treat people in general.
Nope. Was he manipulated by fear and threats of the same abuse if he didn't help? I thought that. I did. But I don't
there's
think
nothing
that's to be the case.
Title, there's nothing in those text messages that Paul read in his testimony during the trial between back and forth of her saying, if you don't do this, I'm going to do this to you. There's
Right.
no threatening of her.
Well, there
threatening
is.
Paul.
There was, and there wasn't a couple, like, he lost his video games or his phone or some electronics. Something. I mean, it was basically something like that. Never the punishment. They all got punished, for lack of a better word, but not to the extent that Timothy got punished.
Yeah, not like Timothy. G
I
is the youngest brother who lived there.
Yeah.
He was young. Like, what was he, like 5 or maybe
5
like
or
3
something around there. Yeah.
Yeah,
I think he was school age because he went.
Yeah.
But yeah, so that she did have custody of him because he was with a different dad.
Yeah, and the grandparents would come and pick him up, would pick G up, and she would make Paul wait at the door so that the grandparents would come in to see Timothy. So when they pulled up, she would bring G out, and they didn't have to come in the house.
She said it's because the house was messy. I'm like, oh, it wasn't because your skeleton kid chained up to his bed? Wasn't that? It wasn't all the locks put on your refrigerator and all your cabinets? Like, everything. It wasn't that.
Or the fact that the grandparents were on the way there, and they're making him do a wall sit in the door of where the grandparents would be coming into the house. So she's like watching this on the video on her phone. She's like, make sure you're right there so they don't come in and see Timothy, like, because he's being punished, standing there against the wall. Ugh.
I mean, it's so bad. So as far as her being tested for mental illness, they never talked about it. They always said she was competent. She understood everything. And if you listen to when the judge was reading her stuff, and even her attorney said the stuff that she was talking about was self-reported. So there's never any proof of anything that's actually happening to her. That's why she was like, well, I feel this way when I eat apples. That's why they were just like, then don't eat apples.
Yeah.
Duh.
Exactly.
Like, just don't eat an apple.
So dramatic.
It's just because she doesn't.
She's like, I'm allergic to apples, but I'm gonna lick it.
Yes. Oh, and
I
my
know
throat
I'm
is
allergic
itchy.
to them, but yeah, I'm gonna do it anyway.
But nothing's happening to me. Okay, don't eat apples. All right, I'm gonna eat another one. I mean, it's just that kind of stuff. And I think she tried to delay the trial. It didn't work. I think the judge would have figured out a way to go on without her anyway. If he had to, like, he brought up Zoom.
Mm-hmm.
Her attorney had her sign a waiver saying, okay, I'm like, I know, like, I'm giving up my right to be there. It's fine. Go ahead. Because he's basically telling her, like, I took it as he's basically telling her, it's not going to change anything.
Yeah.
You're there now. It's not going to change anything.
Yeah. You wanted this. You wanted this right now. Why are you waste of time? Waste of taxpayer time, waste of the judge's time, waste of everybody's time who's in that courtroom. I'm sorry, but it is.
Well, and that I just totally lost my train of thought. I don't know. Because the one thing she didn't have to face when she never came back was she throws up, the judge is like, okay, let's take a 5-minute break, whatever. Then the court day just ends and you don't hear anything else. So then when we start the next day, it's like, okay, where is she? Because now it's time for the jury questions. And boy, did I want to hear those.
Yeah, I know.
And nope, but she didn't have to face them. She never had to face those questions. And she knew that's what was coming after direct or cross-examination. So, woe is me. I didn't throw up, but I'm going to pretend to throw up. I'm going to curl up in the ball on the jail floor, because who in their right mind would do that? And then I'm going to pretend I don't remember any of it. Fine. Great. Guilty. See ya. Like, oh, we have this video here of you. Did you forget that too? Probably. Because you forgot to take, I think you forgot to take some of the cameras down.
Yeah. I mean, all of the cameras. What is up with criminals and putting cameras all over their house? I mean,
no
seriously. People, come on.
I have them on the outside of my house.
Get
but I
the
also live in
outside.
I have a rural area, so you know, it's like that one time that that FedEx driver was like, "How come you have so many cameras?" I'm like, "Why do you care?"
Yeah, you
Don't ask
scout
me. That's
my
a weird
house, girl?
question. Like, why are you asking me that question? That's weird. Don't do that. I'm not answering.
That's why Fat Tony is down there, so he can protect you.
That's right.
He knew that guy was scouting your house. So he's like, why is he looking at all the cameras? What's up, buddy?
What's he doing? Like, he's like, I got you. I got you. So, yeah, weird. Don't do that. All right. Well, we got actually further than I thought we were going to. So hooray for us. We covered everything that I wanted to. So
I guess
gold star. Gold star. I hope Ronnie did not break anything while she was cooking dinner. I hope none of you broke anything today.
I almost needed bubble wrap.
Get your bubble wrap out. Wrap your phones.
Mm-hmm.
Save all of your soft things that you can throw for Thursday.
Yep.
Because trust me, she'll make you want to throw them. If you were mad today, or if you were frustrated today, get ready. Oh, yay.
Oh, yay. Yeah.
Yes, my phone or my watch has already told me to go to bed, so I probably should obey it. I would hate for it to do something weird in the night, like wake me up for no reason. It's almost.
Ronnie's laughing because she's like, I definitely broke something.
Yeah, we know. She's like, "Oops, how'd you guys know?"
Ronnie covers her iron with a bunch of pillows, and then she just throws everything else. She's like, the iron's the only thing that matters.
Oh, she's like, "Oh, my iron! I'm so sorry. Come here. I love you so much, iron. Best friend, BFF. Let's go.
You know what?
Tomorrow we'll iron towels and curtains."
If I ever needed something ironing, I'm gonna ship it to Ronnie.
Absolutely.
You know that's gonna come
be
out
perfect.
real crisp. It's gonna be crisp.
It is gonna be perfect. Effie. That's a good one, whoever. Bobby, what the hell? All right, land in the plane. See you guys all on Thursday. Behave. Till then, 6 p.m. on Thursday. We'll finish up this for now.
Right.
And then hopefully Judge Casey will give his ruling.
Nothing tomorrow?
No, I have dinner tomorrow.
Okay.
So hopefully Judge Casey will give his ruling soon, and we can read the ruling, and it'll say...
Like cheese? Queso?
Queso.
Oh, I thought you said queso.
K-A-C-E-L. He'll be like...
See? You see?
No. He'll just say no. I hope his ruling just says no.
You see?
I see that.
Oh, shit. My bad. Oh, crap. Never mind. I'm never touching this again.
Yes,
People kept commenting, and then I tried to X out of the other one.
I know. I'm up here. Anyways. Oops.
Okay, bye.
All right, see you guys.
Bye.
Bye, guys.
Hot mannequin love is kinda uncanny. Click, like, subscribe, ooh, piece of candy. Looking for my spotlight, chasing my vibe. Still looking for my credibility online. Ooh, hot mannequin love, candy on the floor, don't pick it up. Chasing all the clicks, chasing Everybody's hiding, but I'm bringing you the news. Every little scroll is a mystery, but you stuck around, watch the show with me. Laughs and chaos, that's how we roll. Drop a comment down below before you go. Every little scroll is a mystery, but you stuck around, watch the show with me. Laughs and chaos, that's how we roll. Drop a comment down below before you go.